सीरियल नंबर 1 फौजदारी अपील नंबर 8819 फौजदारी अपील नंबर 8819 विद्वान वकील श्री एस जे भट्ट वकील श्री वीएन अजवालिया राजूभाई वीराभाई नमस्ते बेनी रिटर्न आर्ग्युमेंट આપી દીધું અંગવાળિયાની આવી ગઈ ને આ જેમાં સાંભળો फौजदारी अपील नंबर 6222 वकील श्री डीएम डाभी वकील श्री जेडी जराणी फौजदारी अपील नंबर 1123 वकील श्री जेएम लक्कड़ रकम जमा करवाना एक्सटेंशन દિવસ 30 દિવસ આપેલા 30 દિવસમાં નથી થયા તકલીફ કેટલા માટે 30 days time granted જી સર 30 દિવસ આપું છું બીજા જમા કરેલી સર એમાં એટલું વિનંતી કરી શકું છું કે મને 50% એમ એટલે 30 દિવસમાં પૈસા તો જમા કરાવો ના એટલે 30 દિવસે હું 50% જમા કરાવી દઉં એ તો જોઈશું આપણે કેટલા વિનંતી ખાલી હા तो 30 દિવસ આપું છું સર અને તમારી બધા પૂરા જમા કરે તો પ્રેક્ટિસ આઈ વિલ બાય ટુ બી કોલ સર હા અને હું પર્સનલી એવું હશે તો એન્ડરટેક કરી દઈશ બરાબર હાજી સર આજે 24 છે 24 2 તો આજે 24 2 છે અરે 24 3 સોરી ઓબ્લેશન થઈ ગયું ઘનશ્યામભાઈ જી સોલંકી सारी से बजे वक्त बजे पाची નથી યોગી સ્ટીલ સપ્લાયર્સ માટે ભાગીદારી પેઢીના પાર્ટનર્સ सीरियल नंबर 6 प्रचलन फौजदारी अर्जी नंबर 227-23 वकील श्री केएल लाठिया स्पेशल पीपीसी देव मुरारी वीआर देव मुरारी
નથી આવશે અને એમને કાલ પેપર્સ મે છે ને એમને દેવમુરારી સાહેબની હારે વાત કરાવી દીધી આયોને બોલાવીને
આજે આવવાના છે ને
હા એની કોઈ આઈડિયા નથી છે દેવમુરારી સાહેબ વાત
ટેમ્પરરી બેલ છે એ આમાં કોઈ આવશે પછી 12:30 ચાલુ કરે મારો ઓર્ડર ક્યારે લખાવવાનો પછી એટ હિઝ કન્વીનિયન્સી ઇફ હી ઇઝ કમિંગ એટ 12 o'clock then I will take the matter on 12 o'clock then hear the matter and then I have to dictate the order, pronounce the order. And what is the meaning of this? It has not been able to come at 10:45.
કાલે એમને રિપોર્ટ આપ્યો તો આજે રાખવા માટે
પૂછી લો બોલાય એ તો પછી will pass necessary order in absence of him. Because to that we'll make a note that he is not present. Especially he is not present today. Next. प्रचलन फौजदारी अर्जी नंबर 231-23 वकील श्री केवी शुक्ला
231 232 એક જ ગુનાની છે એક જ ગુનાની છે.
એફિડેવિટ
323, 5506 પછી પાછળથી 3 દિવસ પછી 406, 420 ઉમેરી એમને. વલભીપુરની કોર્ટે નામંજૂર કરેલી છે. ફરિયાદમાં 406, 420 ના કોઈ ઇન્ગ્રેડિયન્ટ્સ નહીં અંદર કોઈ જાતના.
400 420 કે નથી 323 ના ગુના
પેપર્સ નથી આવ્યા.
એમાં સાહેબ આમાં કોલસો લઈને ગયા ને એમાં 6 રિપોર્ટ પોઝિટિવ આવ્યા અમારા ફેવરના, એક રિપોર્ટ નેગેટિવ આવ્યો. એટલે આઈઓ એ પાછળથી 406 નો ઉમેરો કર્યો. અને એ જે મુદ્દા માલ જે છે જે માલ અમે લઈને ગયા હતા ટ્રાન્સપોર્ટેશન મારફત, એ પાછો એ નિરમા કંપનીએ મને વેચી દીધો પાછું છે. એની મેં ડેબિટ નોટ છે, મેં પૈસા જમા કરી ડેબિટ નોટિસ મેં રજૂ કરી છે.
323 એટલે ખબર ના પડે 323 એટલે કંઈક મારામારી થઈ ગઈ.
ઊંઢીજા કરેલી એને એવું ફરિયાદમાં.
પછી આ 400 420 ક્યાંથી આવી?
એટલે પેપર્સ નથી સાહેબ, એટલા માટે સોમવારે સાહેબ રાખો ને એફિડેવિટ નથી
સેટ નહીં, આજે કોઈ પેપર્સ જ નથી.
નથી
રેગ્યુલર બેલ છે.
રેગ્યુલર બિલ છે સર.
મંડે માં બોલાવી લો ભાઈ.
હાજી સર.
બેલ
હા સર.
કે આજે આવી જવાના છે.
હા આવી જશે.
આજે આવી જશે ને?
ના આજે નહીં, હજી વર્દી ફરીવાર અમે લખાવીશું
મંડે.
જી સર.
27
ઉદ્ધારી રિવિઝન અરજી
27 બે વિધાઉટ બેલ સવારે એના કે આવી જવાનું ફોન આવી ગયા.
ઉદ્ધારી રિવિઝન અરજી નંબર 140 21 પીપીસી જોશી, વકીલ શ્રી યુ આર દવે, એફએસ વ્યાસ.
નીચે છે 361 વિથડ્રોલ એપ્લિકેશન આપેલી છે અને એ નામંજૂર કરી એટલે મેં રિવિઝન કરી છે.
નેક્સ્ટ ટાઈમ પેપર્સ લાવી ગયા છે.
આ રેકોર્ડ આવી ગયું છે. પછી વચ્ચે જુદો પક્ષકાર જોડાયેલો તો ખોટી રીતે એને ડિલીટ કરવાનો ઓર્ડર આપે કર્યો. જીબી વાળી મેટર છે.
15 સર આ એટલે 2 દિવસ તો પછી સાહેબ મને 17મી સાહેબ આપને કન્વીનિયન્ટ હોય 17 હા
જી સાહેબ.
સેશન્સ કેસ નંબર 152 15 વકીલ શ્રી વિજી સંઘવી, નરેશભાઈ મનુભાઈ,
ડિફેન્સ વિટનેસ તપાસવા માટે છે અરજી આપી છે.
નરેશભાઈ મનુભાઈ, મનુભાઈ ઉગાભાઈ, ભીમાભાઈ મનુભાઈ, જાગુબેન ભીમાભાઈ.
124 સાંભળવા મળે. વકીલને બોલે
તમારા વકીલ સાહેબ ને બોલાવી લ્યો. સેશન કેસ નંબર 18-20 વકીલ શ્રી બીકે વાઘેલા, વકીલ શ્રી વીબી ગોહેલ, જિગ્નેશભાઈ વૃદ્ધલાલ, વિપુલભાઈ લાલજીભાઈ,
ક્યારે રાખવાની આર્ગ્યુમેન્ટ્સ માટે?
જે છે મંગળવાર, બુધવાર અથવા જે ડિફેન્સ લોયર અનુકૂળ હોય.
બીજી તારીખ રાખો તો
પહેલી કરતા બીજી કરતા પહેલી
જી સાહેબ પહેલી આર્ગ્યુમેન્ટ કરી દઈશ સાહેબ, મેં જોઈ લીધું છે.
એક ત્રણ એફએસ કરીને આપી દીધી. પ્રેમજીભાઈ મજકીરા નંબર 12
સેશન કેસ નંબર 20 વકીલ શ્રી કેબી શુક્લા,
જી સર.
પ્રેમજીભાઈ લાલજીભાઈ,
ચોપડા હોય 12 હાલ વાળું.
ટીપીઓ કલમ 376 મુજબના ગુનામાં નિર્દોષ ઠરાવી છોડી મૂકવાનો 5000 ના જામીન.
ઓબ્લેશન.
સેશન કેસ નંબર 25-20 વિદ્વાન વકીલ શ્રી જયન ઉપાધ્યાય, ધનજીભાઈ કેશુભાઈ, બીજા નથી આવ્યા. PS1 આવ્યો છે, આવી ગયા છે. PSO પ્રવીણભાઈ જે ભટ્ટ, આવે છે. MB નિમાવત PSI હાજર છે.
જોઈએ 12:30 સુધીમાં આવે ઠીક હોય તો પછી એક્ઝામ 30 સુધીમાં આવે.
બેસો બાર. સેશન કેસ નંબર 65-20 વિધાન વકીલ શ્રી યુ આર દવે, વિશ્વરાજસિંહ ગૌતમસિંહ, પંચોતેર
10, 14 અને 15 ને બોલાયા છે. 75.
સહદેવસિંહ દિલીપસિંહ, બચી ગયું છે. એક સ્પેર માં છે અને બીજા છે 8.21. રાજુભાઈ દિલુભાઈ, દિગ્વિજયસિંહ રઘુવીરસિંહ,
હજી કરું ના બધું જોઈએ કદાચ.
જોઈ નહીં તો બે લેવલ પછી
જી
કરજો.
સાહેબ. આવા તો સાહેબ આપને અનુકૂળ મારા ફ્રેન્ડ નો અનુકૂળ તો લઈ લીધું.
સેશન કેસ નંબર 119-21 સ્પેશિયલ પીપીસી યુ આર દવે, વકીલ શ્રી SM જોશી, વકીલ શ્રી JM લક્કડ, વકીલ શ્રી HB જોશી, વકીલ શ્રી VR દેવમુરારી, વકીલ શ્રી KB શુક્લા, રોહિતભાઈ માસાભાઈ,
ઓરિજિનલ કમ્પ્લેન્ટ. exemption
exemption છે અને આ ફરિયાદી તરફ મુદત અરજી છે.
ઓરિજિનલ કમ્પ્લેન્ટ હતી.
જી
આપી દીધી.
કમ્પ્લેનેન્ટમાં મારી ઉપર સવારે એક મેસેજ આવેલો છે અને એ મેસેજની મેં સાહેબ હાર્ડ કોપી રજૂ કરી છે અને સાથે સાથે સાહેબ એક રિપોર્ટ આપેલો છે. કમ્પ્લેનન્ટ છે સાહેબ એને પ્રેશર ટેક્સી થાય છે કમ્પ્લેનન્ટ એના કારણે એની તબિયત એ સારી નથી અને એની
Pressurized from the
ફ્રોમ એક્ટિવ સાહેબ.
I don't know whether
That's why I specifically produced the report.
been having mental stress due to pressure, it will the children. Because of the threat by the accused person, depose in the court?
No, sir, outside of the court.
No.
Yeah,
Because he wants to depose in the court, that is why the accused are threatening.
ultimately they want to settle the matter by the way of certain.
Don't know whether what is the, but if message is very loud and clear, that if substance has been found in this,
Sir,
it will be viewed very seriously by this court. And they are ready to face the consequences. Because this is, we are living in the society where it has been rule of law is prevailed upon everything. Nobody can even dare in his wildest dream to threaten the witnesses because they are under the protection of this court. Anybody try to outreach that, it will be, he has to ready to face the music. That is very loud and clear message. If you want a protection, give an application, we will give all the police protection. If you want people threatening by the phone, you give an application, we will put all the family members' telephone on the surveillance who are calling them.
sir,
Because you are a public prosecutor, you
Sir.
direct the IO, give them 24/7 police protection
sir,
to all the family members of the complainant, because the witnesses are the protection of this court. Nobody can, in the wildest of dream, can think about it to threaten the witnesses. So even I request all the accused advocates also pass on this message to all your clients.
Definitely.
So this is,
Definitely.
if I don't know at this stage, because I am not going to make any comments, but if I found substance in this allegation,
We never inspired them.
no, if found substance in this allegation,
So,
then it will be viewed very seriously and they have to face the consequences. And you are at liberty, whatever remedy available with you,
Sir,
it
sir.
is known to the law. You can explore that remedy also, which are remedy available to you as a witness.
yes, sir.
But this will, if found substance, I don't know at this stage, I don't want to say whether the mention is correct or not. I can't say at this stage whether the what is been stated by the complainant is true or not. I don't know whether maybe true, maybe false. I don't know.
right now, we cannot,
If substance found, then
that is always, Your Honor.
it will be viewed very seriously. That is
That
a
is
very clear and loud message. If found substance, then ready to face, hear the music then.
રોહિતભાઈ માસાભાઈ, યશપાલસિંહ નરેન્દ્રસિંહ, શક્તિસિંહ નરેન્દ્રસિંહ, નરેશભાઈ નાથાભાઈ, હસમુખભાઈ નો એક્ઝામ છે, કલ્પેશભાઈ નાથાભાઈ, ભાવેશભાઈ નો એક્ઝામ છે, સંજયભાઈ જીરટલાલ, બે એક્ઝામ છે.
All are represented by an advocate. Okay, except number 6. No, not represented by advocate is 6.
છ નથી રોક્યું.
6 નથી રોક્યા વકીલ. હા. એ જાતે કેસ ચલાવવાના. 6 નંબર જાતે કેસ ચલાવવાના. એટલે એમણે વકીલ નથી રોકેલા. એટલે 6 નંબર કોણ છે? સાહેબ આવશે તો મુદત નહીં મળે કે મેં વકીલ નથી રોક્યા કે આજે જ મારા વકીલ આવેલા છે. એ ગ્રાઉન્ડ ઉપર કોઈ મુદત નહીં પડે. બરોબર? આ ત્રીજી મુદત, ચોથી મુદત છે. Must be not been understanding Gujarati properly or don't know. Next time on that ground matter would not be adjourned, or on that ground witness would not go back. That is 100%, I am sure. What will be the next that what is going to happen. I am અત્યારથી કીધું એ ગ્રાઉન્ડ ઉપર કોઈ મુદત નહીં મળે કે આજે જ મારા વકીલ આવ્યા છે કે નવા વકીલ છે મેં પેપર વાંચ્યા નથી. ઓન ધેટ ગ્રાઉન્ડ કોઈ મુદત નહીં મળે. હવે આમાં ફરિયાદ મુદ્દામાલની જરૂર નથી. ફરિયાદી
એવું છે કે એની પાસેના જે ઓર્નામેન્ટ જે રેન્સમમાં આપેલા ને એ ઓર્નામેન્ટ એમના પ્રોટેક્ટ ને ડોર કરેલા છે એ કમ્પ્લેનન્ટની પાસે જ છે. અને એનો સાહેબ એનું જે ડિપોઝિશન ચાલુ કરશે એ વખતે એ લેતા આવશે અને ફોટોગ્રાફ છે એ લેતા આવશે. કેશ છે એ સાહેબ કોર્ટમાં છે.
બીજો કોઈ મુદ્દામાં
ના સાહેબ બાકીના કપડા છે અને એક સાહેબ લાકડાનો ધોકો છે સાહેબ.
whether it's required
એટલે સાહેબ
during the deposition of the complainant because મુદ્દામાલ આવ્યો નથી.
સાહેબ એક રિક્વેસ્ટ સાહેબ આપ સાહેબને કહું કે એક મુદ્દામાલનો ધોકો છે એ 37 નંબર છે. પછી સાહેબ એ 38 નંબર. પછી એક છરી છે એ 39 નંબર. એક શર્ટ છે એ 32 નંબર અને પેન્ટ 33 નંબર.
પછી મુદ્દામાલ અહીંયા નથી આવ્યો. this is what
તો સાહેબ એ છે સાહેબ
પોલીસ સ્ટેશનમાં છે કે FSL માં
સાહેબ FSL માં તો સાહેબ એની મુદ્દામાલની સાહેબ યાદી
નીલમબાગ પોલીસ સ્ટેશન છે.
નીલમબાગ પોલીસ સ્ટેશનમાં પડેલી
ખબર નથી પોલીસ
નીલમબાગ મુદ્દામાલ ક્યાં છે આ કેસનો? એટલે પોલીસ સ્ટેશનમાં પડેલો છે ને? એટલે FSL માં કહો કે પોલીસ સ્ટેશનમાં પડેલો?
સાહેબ FSL માં તો સાહેબ લગભગ નથી ગયેલો.
તો પોલીસ સ્ટેશનમાં જ પડ્યો છે ને? આટલા જમા કરી દો ભાઈ. પોલીસ સ્ટેશન માંથી નીચે જમા કરી દો ત્યાંથી અહીંયા આવી જશે.
એટલે સાહેબ એ વખતે પેન્ડેમિક સિચ્યુએશન પછી ક્રિએટ થયેલી અને એ વખતે શરૂ તો થઈ જ ગયેલું માર્ચ 20 માં.
FSL માં નથી કોઈ મુદ્દામાલ FSL માં મોકલેલો
જરૂરી નથી સાહેબ એવું ખાલી.
એટલે પોલીસ સ્ટેશન માંથી તો જમા કરી
question of 2 or 3 hours at the most maximum.
તમે કહી દો આઈઓ ને મેં જમા કરી દો
સાહેબ આઈઓ ને ઇન્સ્ટ્રક્ટ કરી દઉં છું આજે. ભાઈ ભાઈ તો
નવમી 10મી
નવમી સાહેબ મારે બીજી એક ફોર્મમાં સ્પેશિયલ ટીપી કરી છે. 30મી 36મી સાહેબ જો અમુક
9-10 આસપાસ બને 10 પછી 10 પછી સવાલ હોય ને
ચાલશે 13th
14-15 માં ચાલશે.
13મી સાહેબ રાખીએ છે
13મી
હાલશે
13
સેશન કેસ નંબર 32-22 વિધાન વકીલ શ્રી SP કોટિયા
પેલા માટે રાહ જોઈએ છે. બીજા વીકનેસ આવે તો
સુભાષભાઈ અમાન નંબર
આગલી મેટર પંચ બાકી
પૂરું થાય પેલા આમે છે બીજી એક મેટરમાં ઘડિયાળ ક્લિયર કરી છે અને એમના પર વકીલ પણ નથી એટલે એમ નથી.
ક્યાં વકીલ જ નથી લોકો.
અરે અહીંયા નથી.
સાહેબ ત્રીજી રાખવી હું
બહુ
સાહેબ એટલું બધું
બોલો નથી કરવી ભાઈ.
એટલે હું મને બીજું પણ
He don't want to create any sensitivity or some.
મને ખબર નથી what is the substance. મને એવું છે
મંજુભાઈ એવું નથી
તમારી વાત નથી.
આપી છે એનું હું અર્થ સમજુ છું કે મેં શું
ભાઈ સાહેબ તમારી વાત નથી. અમે કંપની
Can we,
અમારા એક્સક્યુઝ ને તમને આપણે પર્સનલી
Your Honor, Your Honor, can we seek
તમારી વાત
copy of,
કમ્પ્લેન નથી. તમે તો આવતી ને વી આર ઓનલી શબ્દ
can we seek the or copy?
કોપી માંગવી તો માંગી લેજો વાંધો નથી. એ તો મેસેજ માં
That we can-
મેન્ટલી પ્રેશર કે સમથિંગ એક લાઈન એટલું લખે
That we can understand, Your Honor. To
I
see,
don't know whether
It
there
is
is
also serious. They have to stay.
what regarding the truthness I don't know. But if found substance Then it is
undoubtedly no.
નહીં appeal થઈ રિવિઝન થઈ ત્યાં સુધી કોઈ જાહેર પોતાની પ્રેશરાઇઝ ટેકનિક છે ના એટ ધ ટાઈમ ઓફ ટ્રાયલ પ્રેશરાઇઝ થઈ વાત ઉત્તરભાઈની વાત
Investigate, sir. That is the investigate, sir. Defense સાહેબ જો સાહેબ એવું કહેતું હોય કે આવું નથી તો સાહેબ એને કોલ ડિટેલ રેકોર્ડિંગ
I know very well what I want to do.
તમારી વાત
બંધુભાઈ એવું કહે છે ને, high profile કરી દેવું.
તમારી વાત નથી ઉત્તરભાઈ મેં હજી વાત કરીને કહું છું આ તમારી કમ્પ્લેન જ કરો તમે કહો જ ને તમે તો તમારી સેવા બજાવો એમાં કોઈ સવાલ જ નથી ઉત્તરભાઈ
હવે 13મી નથી કે
14-15 માં ઉત્તરભાઈ તમે શું
જયંતિ ભાનુશાળીમાં મારે તે દિવસે
નોઈસ
અને પૂના
15-16 માં
આવે છે, એ લોકો ત્યાંથી એડજસ્ટ કરીને
15 વર્ષ
પછી સત્સંગ રાખીએ છે.
નોઈસ
આપણે બધાને અનુકૂળ હોય તો સાહેબ.
બધા આઝાદ છે
તો એવું નથી.
વધારે પડતા છે ને જે એટલે બીજું કાંઈ
હું ક્યાં નામ મને એવું નથી.
તમારે બહાર હોય છે તો પહેલા અમે તમને પૂછીએ છીએ અમે ત્યાં રજૂઆત કરીએ
એની એવું નથી. આપણે કહું ને કે હવે બધું
ઓકે કાંઈ વાંધો નહીં. ના ના તમારી વાતની વાત છે
સત્તર
ઓકે
કે?
ને.
17 એસપી કોટિયા એમાં શું ડોક્ટર આયા
ડોક્ટર બ્રિંજલ દેવરા
આવી ગયા સારું પેલા ડોક્ટર લઈ લઈશું
જે કોર્ટના રેકોર્ડમાં છે કે એમને આપેલા છે અને she might not be called for that because she લાવ્યા છે and otherwise તમારી પાસે ઝેરોક્સ છે મને ખબર નથી આમાં આપણા રેકોર્ડમાં છે પણ જે ઝેરોક્સ ને આંખ પાડવી પડશે તાત્કાલિકમાં એક સર્ટિફિકેટ નથી દસ્તાવેજી પુરાવા સર્ટિફિકેટ છે injury of accused there are actually 2 certificates more than what is provided in charge there is no certificate of the injury of the accused
પેલા એને તો આવી જવાથી witness
એટલે જો લાયકાત ન હોય તો પછી આ બધી ફરી ડકો થશે આજે આ પ્રોવાઇડ
ના ના તમે અમને દેખાડો સરકારી વકીલ એ જ વેરીફાઈ કરી લેશે એ જ ડોક્ટર ના છે બીજા સર્ટિફિકેટ્સ નેક્સ્ટ
સેશન કેસ નંબર 33-22 વિધાન વકીલ શ્રી BM કલ્યાણ ધનજીભાઈ ભીમાભાઈ
પીએસઓ સાહેબ એમાં પીએસઓ ને બોલાવેલા પણ એક તપાસના કામે કઈક ગયેલા છે એટલે આજે નહીં પહોંચી શકે તો નેક્સ્ટ હા હા અરજી આપી હા સાહેબ એમાં એક ડોક્ટર સારવાર કરનાર છે એમનો હું સાહેબ નંબર લખાવી નાખું તો બેને સાથે બોલાવી લઈશ
એને તપાસવાના
હાજી હાજી
It may be 8th or 10th year. I'm at Kota.
આમાં ડોક્ટર થઈ ગયા
No, 8મી તારીખે
સારવાર કરનાર થઈ ગયા
10મી
જી
10-3
વાંધો નહીં સાહેબ
ડોક્ટર થઈ ગયા
10-3
ઓબ્લેજર
સેશન કેસ નંબર 121-22 વકીલ શ્રી PP જાડેજા અનિલભાઈ પ્રેમજીભાઈ
આરોપી
નમસ્તે ફરિયાદી અને એક પંચ છે ફરિયાદી મહાવીર પ્રસાદ મૂળચંદ અને એક પંચ છે સંજયભાઈ ભાણજીભાઈ
કોણ આવ્યું
આરોપી
આરોપી આવી ગયા.
અચ્છા ઓકે
ત્યારે સાહેબ હાજર નહોતો એટલે એમને કંઈક તબિયત
કોને ફરિયાદીની તબિયત તમે એમાં તારીખમાં પંચ આપેલા છે
આ પંચ એક આવ્યો છે
પંચને લઈ લઈ પંચ આપેલા છે. એમને પછી તમે તારીખની જાણ કરી દીધી
જી જી જી
બેસો
વાંધો નહીં, એટલે એમને તારીખની જાણ કરી દેજો એમ એવો જ જવા દો ને તારીખની જાણ કરી દેજો યસ
સેશન કેસ નંબર 149-22 વકીલ શ્રી NH ચૌહાણ શિવરામભાઈ વીરાભાઈ શિવરામભાઈ વીરાભાઈ, મોહનભાઈ વીરાભાઈ, પ્રાણલાલ મોહનભાઈ, મૂળજેભાઈ મંગાભાઈ.
તમારા સામે ઇફિકો કલમ 323, 394, 395, 506 બે સાથે વાંચતા કલમ 114 મુજબ સહમતનામું ફરમાવવામાં આવે છે. ગુનો કબૂલ છે, કેસ ચલાવવાનો છે ને કેસ આરોપી કેસ ચલાવવાનો છે ને. આમાં
ફરિયાદી
10મી 10મી માર્ચ મુદ્દામાં જોઈને આવી ગયો છે. 10/3 ફરિયાદી. ઓકે, પછી ભાવેશભાઈ નાનજીભાઈ ચૌહાણ.
સેશન્સ કેસ નંબર 1723. ભાવેશભાઈ લાલજીભાઈ,
બી માટે
આપી દીધું.
ડપોરો જો થઈ
ચાર્જ માટે 14/3 14 એસીબી 4/16
સ્પેશિયલ એસીબી 4/16. વકીલ શ્રી આર કે જોશી, વકીલ શ્રી યુ આર દવે, રામભાઈ ઉકાભાઈ.
ફરિયાદીનો રિપોર્ટ
છે. લગ્ન પ્રસંગમાં વારંવાર.
એને મને ફોન કર્યો હતો.
બે હાજર છે.
ફરિયાદીનો રિપોર્ટ માર્ચ ચાલે શનિવાર.
જી સાહેબ.
18
જી સાહેબ.
તમે 16 થી 26 માં નથી.
એવું કરું. એક સેકન્ડ સાહેબ, એવું કરીએ 18મી સાહેબ હું મારી ક્રોસ પૂરી કરી નાખું, ચીફ લઈ લેજે, પછી એમના પૂરતું સાહેબ બાકી રાખીએ, એવું કઈક કરીએ. બસ સાહેબ
18
જી સાહેબ, હું હાજર રાખીશ ફરિયાદી.
બરોબર ને? આખો દી ચીફ તો હાલે. ઓબ્લાય સાહેબ.
સ્પેશિયલ પીપી વિહાર દેવ મુરારી કે લાઠિયા, પ્રકરણ પદાની 227/23.
વેરીફાઈ થઈ ગયું.
હા સર, મેં પેલું રિપોર્ટ મોકલ્યો છે, કંકોત્રી મોકલી છે મેરેજ છે સાહેબ. પણ સાહેબ એને જામીન અરજીમાં તો જે છે એ સાહેબ આખું કારણ આખું મેરિટ નું લખ્યું છે અને છેલ્લે ટેમ્પરરી લખ્યું છે. સાહેબ હાઈકોર્ટ, જી સાહેબ, અને સાહેબ હાઈકોર્ટમાં પેન્ડિંગ છે. હાઈકોર્ટમાં જામીન અરજી પેન્ડિંગ છે.
ક્યારે
ના એટલે આમાં તો એવું લખ્યું છે
વિથડ્રો કરી લીધી?
હા સાહેબ, તો કશું જામીન અરજીમાં સાહેબ પેન્ડિંગ લખ્યું છે.
પ્રોડ્યુસ કરી દીધું, વિથડ્રો કરી દીધું.
હાજી સાહેબ.
એમના નાના ભાઈના જ છે.
હા સાહેબ છે.
26 રવિવારે.
છાપતા સાથે
શેનો ઓફેન્સ
છે સાહેબ? પ્રોહિબિશન છે. કઈ વાંધો, હાજી સાહેબ, વાંધો છે. જી સાહેબ, વાંધો નથી. જી સાહેબ વાંધો નહીં.
પોલીસ વાળા ક્યાં બધો ફેરો
જી સાહેબ વાંધો નહીં.
આજે સ્પેશિયલ પીપી ની સ્પેશિયલ આર્ગ્યુમેન્ટ હોય ને.
જી સાહેબ
આવતીકાલ સવારથી 25મી સવારથી 27 સાંજ સુધી આપીએ
જી સાહેબ વાંધો નહીં.
બરોબર લગાન તો એ હાજર થઈ જજો પણ એટલે તમારા અસીલ ને તમે કહેજો એમ
જી સાહેબ વાંધો નહીં.
તો પછી સિરિયલ નંબર 10 એરલાઇન બી લઈ જજો ઓર્ડર દીએ સિરિયલ નંબર
નહીં, આજે પછી ઓલી કોમર્શિયલ અપીલ ચાલવાની ને સાહેબ ને
આ વારથી બધી અપીલ ચાલવાની છે સિરિયલ નંબર
કોમર્શિયલ
વિધિ સંઘવી
યસ 126 સાંભળવાનું શું છે?
બોલી 3 સાક્ષીને તપાસવાના હતા ને
ત્રણ સંસ્થાની અરજી આવી.
શેના માટે તપાસવાના છે એ માટે મારું કહેવાનું એવું છે કે મેં એમને ક્રોસમાં પૂછેલું કે આ સમય વખતે આરોપીઓ મેં વિગતવાર એમાં નથી લખ્યું છે આ રહી મારી એપ્લિકેશન.
આ તમે નોટ પ્રેસ કરીને આ અત્યારે કરશો
એટલે એમાં મેન્શન નહોતું કર્યું આ વિગતવાર એપ્લિકેશન. મેં રીઝન લખ્યું છે કે કયા કારણથી સાહેબ તપાસ એટલે
યસ
યસ
એલઈબી નો પુરાવો રેકોર્ડ ઉપર લાવવાની વાત છે સાહેબ.
નહીં એમાં મેં ક્રોસ એક્ઝામિનેશનમાં કમ્પ્લેનન્ટ ને ક્રોસ એક્ઝામિનેશનમાં પૂછ્યું છે
કયા બેને તપાસવા છે એક જ દિવસમાં બે પતિ એવા કયા છે
ત્રણે જ હાજર રહેશે 3 જણા છે.
તો બે જણ કહેશે એલઈબી તો એ તો પુરવાર થશે જો તમારી એલઈબી હશે તો કયા બે તમને લાગે છે કે બહુ ફર્સ્ટ ક્લાસ બોલશે અહીંયા
તમારા લાભમાં બે હારું કોણ બોલશે?
ગમે એ સાહેબ
કારણ મૂળ ફરિયાદી
એક અને બે ને સાહેબ બોલાવ્યું એક અને બે ને 1 અને 3 ને બોલાવો તો 1 અને 3 ને બોલાવો
તમે કહો એ
1 અને 3
અનુક્રમ 1 અને 3
3
આના કરી દેજો in view of the order passed below execution so this disposed of 124 તો રહી ગઈ ચલો બન બોલો એ ચાલે 13મી
હા વાંધો નહીં.
તમે લેતા આવશો
હા લેતા આવશો
સમજ તો કાઢી
ના ના લેતા આવશો
13 ભટ્ટ
એસ જે ભટ્ટ વીએન અજવાળિયા ડીએમ ડાભી
ટેડી કેલાણી
ચેડી કલાણી
ડીવી એક્ટ ની સામેની અપીલ છે નીચેની કોર્ટે ઓર્ડર કર્યો ઓર્ડર તારીખથી પૈસા મળ્યો અને ઓછો કરેલો છે સામેવાળા પોલીસમાં છે પૈસા ભરતા નથી 73,000 રૂપિયા ચડી ગયા છે પેલા પૈસા બે બાળક છે બાળક એ તો કરી જ છે પછી રિવિઝન લાવો પૈસા પોલીસમાં જો હા આપી અરજી તો આપી ન્યાય જેવી રિકવરી અરજી કરો ને ઓર્ડર થઈ ગયેલો છે તમે જાણો છો પછી ભરવાની તમારી જવાબદારી છે રિકવરી અરજી કરો તો ભરવાનો એવો ક્યાં કાયદો છે
અરે મિસ્ટર ડાભી એડ્રેસ ટુ ધી કોર્ટ
પણ સાહેબ એમાં એવું છે
કેલાણી-
રિકવરી કરો ઠીક છે સાહેબ, order થઈ ગયો.
Pass an order then to argue before Mr. Gera.
અમારી અરજી છે, અરજી બોલો સાહેબ, પેલા પૈસા ભરે પછી ઓફિસે ચલાવવા માંગુ છું. મૂકી અરજી મારે ડરે.
Books for year.
એટલે બે બાળક છે સાહેબ, એક રૂપિયો ખોરાક
જો એ પૈસા
શેરડી દે છે, પણ બાળકોને સારું ભવિષ્ય શેરડી મારે છે.
ચલો એ પૈસાનું જે હોય બાકી હોય
મેં આવી
આ તો રિકવરી તો એવી વસ્તુ છે કે ઓર્ડર પાસ કરી દીધો હોય છે but if a person is not honoring the orders, that is why the provision is there.
એમ નહીં, તો ભલે તો 125
Result આવે છે.
ક્યાંના પડી છે? નામદાર કોર્ટને કહો. આ તો રિકવરી અરજી કરો છો, order ત્યાં પછી તમે બીજી અરજી કરવાની.
Once order has been passed, 125(3) શેના માટે છે કે if you are not complying the order, that is why 125(3) is there.
Right, sir.
But otherwise you have to comply the order itself. Once the order has been passed by the court, either you challenge that order. If you are not challenging that order, then you accepted the order. Then you have to either TDS or under section 125.
Right. આ રીતે આવી ગયું છે, ભાઈ નીચલી કોર્ટનું સિયોર કોર્ટનું આવી ગયું, સારું આનંદ કે દે કરી બોલો પૈસા ભરો આવતી મોદે કે ભરી દો એટલે તે કરી
15(3).
હાજી ના મને કહી દઉં, હમણાં નીચે મળશે ને મારા રોજ ભેગા થાય
17.
કા 17 ને કા 14
17.
હું જાણ કરી દઈશ 100%.
17 પછી હવે કોઈ છે હવે વિટનેસ એમાં આવેલા
વિટનેસ છે સિરિયલ નંબર 1 ડોક્ટર યુટીપી
ડોક્ટર માં
16 સિરિયલ નંબર 16 માં ડોક્ટર છે.
લઈ લીધું સર્ટિફિકેટ
ડોક્ટર નો
સર્ટિફિકેટ બસ એ નથી કરાવવા. On the court record, I have taken the copy from the honorable court. And
જોવો છો પછી 2 PM જોવો તમે આરોગ્ય બીજું 27 તારીખ બરોબર પછી 24 તારીખનું સ્નેહ લખાડેલું
સર્ટિફિકેટ છે
28 સુભાષ 27માં સુભાષ ભાઈ નો કેસ પેપર છે સર્ટિફિકેટ તો મારી પાસે નથી અને એનું સર્ટિફિકેટ 27 તારીખે ના વાંધો નહીં
સહી થઈ ગઈ તારીખ આપી દીધી છે યુટીપી માં ગઈકાલે હતી જવાનું ને
પોલીસ એની કઈ લેવા જ નથી ઝેરોક્ષ છે એમાં બેન લોકલ છો તો ઝેરોક્ષ સેટ કરીને આપો નેક્સ્ટ ટાઈમ બોલાવવા પડશે
શું થયું
અમુક સર્ટિફિકેટ જે ડોક્ટર સાહેબ લાવ્યા છે એ મારી પાસે
એ છે બે પાસે નથી ઘણા એને ઝેરોક્સ એ સાહેબ પાસે છે એટલે એવો કોઈને પ્રેજ્યુડાઇઝ થાય એ સાહેબ એવી રીતે તો મેટર
એપ્લિકેશન આપી દો કે ડોક્યુમેન્ટ્સ
હા.
રજૂ કરવા પડશે
હા.
તમારે.
એ એક ડોક્યુમેન્ટ સાહેબ રજૂ કરવું પડશે સર્ટિફિકેટ
એમની પાસે નથી કોપી.
મારી પાસે નથી
એમની
સાહેબ.
પાસે
કારણ ઝેરોક્સ એ આમાં પડી છે અને સેટ આપી દો
ક્યારે બેન અનુકૂળ આવશે?
આપણે કઈ અનુકૂળ આવશે ડેટ લોકલ છું સર્ટીમાં લોકલ જ છે સાહેબ આપ કેવા જીવ છે સાહેબ ને અનુકૂળ હોય એ પ્રમાણે
છઠ્ઠી છે
હે?
છઠ્ઠી એટલે ટોપિક 4
ઝેરોક્સ કરાવી
ટોપિક
હા બધે ટોટલ કરાવી હા જરૂર નથી
છ ત્રણ. પછી બીજા તેમાં
સર્ટિફિકેટ છે ને જે છે તારીખ
સિરિયલ ઉપાધ્યાય એમાં આવે ને?
13 માં છે સિરિયલ નંબર
13 માં સિરિયલ ઉપાધ્યાય. હા. એમાં કોણ આવેલું છે?
એમાં આવ્યો પીએસઓ છે
હા હું એમાં
ધનજીભાઈ કેશુભાઈ
છે સર
પ્રવીણભાઈ જે ભટ્ટ પીએસઓ પ્રવીણભાઈ ભટ્ટ આવી ગયું.
પછી છે ત્યાં થઈ જશે તો પછી હું
આરોપ વખત.
ત્રણેય ની બેસાડે ત્રણેય છે ને
તો બાર જાવી મેં એન્ટ્રી કરી છે ને નથી કરી
હું ખાલી 4 માં હતો.
પછી હું
સાહેબે પોતાના રૂબરૂ ફરિયાદ લીધી, પોતે જ દાખલ કરી, પોતે જ તપાસ કરી.
તમે કઈ નથી કર્યું પીએસઓ ના ચાર્જમાં હતા પણ જે આઈઓ છે ને એને ફરિયાદ લીધી એને સ્ટેશન ડાયરીમાં
એમાં એવું છે સાહેબ
આજે કોણ આવ્યું છે
નિમાવત
કાંઈ વાંધો નહીં આરે સોલંકી નો પછી લઈ લે
આજે
પેલા એડી દાખલ કરીને એડી તપાસ માં આવશે.
હા વાંધો નહીં. તમે બેસો આપણે ડાયરીની ઝેરોક્ષ આપીને જજો કરી નકલ કરી એટલે પછી પાછળ કોઈ ટેકનિકલ વાંધો ન હોય.
એમબી નિમાવત
કીધું તો ગઈકાલે જ આયા હતા. આરામ સોલંકી ગઈકાલે ભૂતથી કાલે આયા.
ગઈકાલે આવ્યા હતા ને
હા પછી બોલામાં ઇનિશિયલ
ખ્યાલ નહીં ને બધું આઉટ ઓફ જતું રહ્યું. બાકી ગઈકાલે આયા હતા આરામ સોલંકી.
હા.
ભૂતથી જ આયા હતા.
ઓલું ઇનિશિયલ હોય આપણે પૂરી ખબર આવી જતી હોય ને સરકાર તો આપણે આપણે એક જ બોલાવીએ એવું ન હોય. બરાબર.
સર આવે છે 5 તો ત્યાં ટ્રાફિક જામમાં છે 5
क्या किया तो लड़ना एडवोकेट बना
बिल्कुल कोई नहीं
ऑन रिकॉर्ड हाँ
I want to show to your honor few more documents before I go to the order passed by the learned trial court. And to avoid any waste of time, what I have done is that I have prepared a convenience compilation. So your honor may have a look at that.
Yes.
The first is a letter of 21st September 21.
Yes.
It is at 3/21. That also I have mentioned at the top. This is from defendant number 1, Mr. Azman, to defendant number 3, bank. Dear sir, reference to your message advising us accept of the SWIFT message from Canara Opening Bank, Mumbai, confirming the cancellation of letter of credit number so and so. In this regard, buyer has now cancelled the memorandum of agreement and copy of the addendum number 6 is enclosed herewith. Request to kindly cancel the said letter of credit and advise the opening bank at the earliest. So defendant number 1, the seller, is writing to his own bank to cancel the LC. To the same effect, your honor will find the letter, second letter, on 27th of September 21, which is 3/23.
Yes.
Dear sir, reference to your message advising us accept of SWIFT message from Canara Bank, Canara Opening Bank, Mumbai, confirming the cancellation of the LC. In this regard, buyer has cancelled the deal from his side. He has also given undertaking to not claim any damage for the same in future. Addendum number 6 is enclosed herewith. Request to kindly cancel the said LC, the opening bank at the earliest. In spite of several reminders to the opening bank, they have still not taken step to cancel it themselves. So again, Mr. Asman Mohammed is writing on 27 September to their own bank to cancel the LC. Then the third letter is 3/44, where DBS Bank's officer, Mr. Santosh Nagaonkar, is informing that cancellation took place yesterday and you will receive the SWIFT message soon. This is the communication from Singapore DBS Bank to Canara Bank, defendant number 2. Your Honor will find this is from Mr. Santosh Nagaonkar to Vishwanarayan Kende of Canara Bank. So this is that third letter, 3/44. Then later on, they try to come out with a story that we were referring to some different LC and not this LC. But at least this document shows that they had agreed to cancel the LC. Then, sir, Your Honor may kindly see 3/44, next letter at item number 4 is a 1st October 21 letter. This is again from Mr. Asman Mohammed and addressed to DBS and Canara both. It is addressed by defendant number 1 to defendant number 2 as well as defendant number 3.
Yes.
One charge. And kindly see only the last point, number 4. I once again request you to please be calm and let DBS complete their procedure for cancellation of the LCs. By pushing and forcing them, I will not be any faster, because what I learned from them is that they have to work as per the bank protocols and can't do as we instruct them. Then, sir, 14th October, next letter, 3/31. This is again defendant number 1 to defendant number 3.
Yes.
14th October. Kindly send the SWIFT message as follows. Cancellation of the LC. SWIFT message content, applicant to cancel MOA and the LC number so and so accordingly. So this is 14th October. Kindly see the next document again of 14th October at 3/32. Reference to the above subject, kindly be informed. We agreed for cancellation subject to original documents returned to beneficiary. Should you need any further information. Then, sir, next document is 26 October, 3/44.
Yes.
This is again from Mr. Asman Mehmed, that is defendant number 1 to defendant number 2. Subject Canara, defendant number 3. Reference to your last email received, kindly be informed I had already advised applicant to send message via Canara Bank, stated that vessel had not been delivered to DBS Bank. Same swift message as per our instruction had been done. Kindly assist to have the LC cancelled soonest. This is 26 October 21. The next document is on page 8. Your Honor will find this is again from defendant number 1 to defendant number 3. Reference to my earlier email sent today, I hereby attaching you the previous SWIFT message from Canara Bank forwarded by applicant to us for your kind perusal. Kindly be informed we had already submitted official letter for cancellation along with the original copy of the amendment to the bank. I would appreciate if you could inform the Trade Department to cancel the LC soonest. This is 26 October 21 from defendant number 1 to defendant number 3. The next page, page number 9, your Honor will find is 28 October. This is from defendant number 1 to the plaintiff.
Yes.
Dear Dilawar Bhai, kindly be informed your LC will be cancelled by next week, Wednesday. As we are arranging your payments, we will keep you updated with regard to LC cancellation. This is 28th of October 2021. And on 11th or 12th November, I am filing the suit, because the cancellation did not take place and DBS insisted payment on the so-called maturity date of 19th November. And the last page of the compilation is 30th October 21, which is again from defendant number 1's agent, Mr. Apurva Gandhi, to the plaintiff. As per the last email we all received from Mr. Azman, the LC cancellation will be concluded on Wednesday, the 3rd of November 21. Rest of the explanation will be sent to you by the end of the next week. So, sir, these are the only documents which I wanted to show today, and took this opportunity to do the convenience compilation so we can move faster to the arguments now. Sir, now kindly see that the learned judge has considered all this while granting the injunction. Your Honor will find that the learned judge has passed an order which your Honor will find starting from it's a very long order running into 90 pages, starting from page 66 of the appeal record.
Yes.
Your Honor will find that the order starts from page 66, page 1 of 90, and the reasoning start from page 109, internal page 44.
Yes.
I will very briefly take your Honor through what I consider to be the relevant part of the reasoning of the lower court. Your Honor finds that the learned judge deals with all the three issues from paragraph 9. Kindly see on page 110,
Yes.
the last two lines. But the main condition of payment is to be made after 150 days from the date of physical delivery of the vessel remained the same. That condition number 42C of the letter of credit, it never underwent any change in spite of 3 amendments. And that condition provided that Canara Bank was to make payment 150 days after the delivery of the vessel. Now, this condition is admittedly not fulfilled. The vessel is not delivered. Therefore, the liability to make payment did not arise at all. And this, the learned judge has, in my submission, rightly found to be one of the main conditions, and which is not amended. Then kindly see further on the same page 111. It is undisputed fact that by virtue of amendments in the MOA, the date of delivery of vessel were changed from time to time, and vessel was ultimately not delivered to the plaintiffs. In pursuant to the MOA, the LC came to be opened on such and such date by defendant number 2 in favor of defendant number 3. One of the important condition of payment provided that it was made after 150 days from the date of physical delivery of the vessel. Notice of readiness is to be sent by the seller. So, with respect, the learned judge very rightly emphasizes 2 aspects of the LC. One is condition number 42C remaining unchanged, and second is requirement of the seller issuing a notice of readiness to the buyer. Your Honor recalls that when the LC was originally granted, it was to be a part of the document to be presented. Therefore, it was in 47. Then by amendment, it was removed from 47 and put in the additional condition. My submission is that that change from document to condition made no impact on the obligation of the seller to issue the notice of readiness, of the obligation of Canara Bank to issue a confirmation that the buyer has received the notice of readiness. And it is only on the fulfillment of 2 conditions precedent that DBS becomes entitled to receive payment.
Yes.
Now, sir, Your Honor may kindly go to the next page. At the end of page 112, last line, it was also conditioned that the seller certifying that the vessel at the time of delivery is free from all encumbrances and in a delivery condition. So deliverable, but in delivery condition. So at the time of the physical delivery of the vessel has to be free from encumbrances. Now it is duly established on record that the vessel was under the order of arrest of the Indonesian court, and that order of arrest had continued. Therefore, it was not and cannot be said to be free from encumbrances.
Yes. Yes.
Now, Your Honor may kindly go to page 113, last 3 lines. But all throughout these amendments, all other terms and conditions will remain the same. Now, looking to all the amended memorandum of agreements, it clearly transpires that initially vessel was to be delivered on 25 May 21 and date of cancellation was 5th June 21. Then after, in pursuance of amendment, expected date of delivery was changed from time to time. These facts clearly shows that defendant number 1 from the beginning not in a position to deliver the vessel. Therefore, the date of delivery was changed from time to time. There are total 5 amendments in the MOA. It is a classic case because there are 5 amendments in MOA and it is for change of date of delivery of vessel. One can easily infer that defendant number 1 was neither in a position to deliver the vessel nor want to deliver the vessel, and he wanted to commit fraud with the plaintiff. Now, to this part of the reasoning, my friend has raised certain arguments as to how this fraud can be a matter of inference. With respect to my friend, I must say that fraud is always a matter of inference, because no system, either of science or law, has found out a device to map a man's mind. It is not that I can have an X-ray of the man's mind to find out from a print that yes, there was a fraudulent intention. Fraud is a matter of inference from the accumulation of the circumstances as they have emerged in this case, as it would happen in every case. Therefore, with respect, the learned judge is prima facie right in inferring the fraud that this defendant number 1, initially promising the vessel on 15th May, keeps on extending up to September, every time giving hopes, every time giving reasons of COVID and lockdown and the other reasons, just to push the delivery of the vessel. And then he is sitting on my letter of credit, finally agreeing to the cancellation of the letter of credit, that MOA is cancelled. He himself writes to his own bank to cancel. He assures me that he is writing to cancel. In one of the mails which I showed today, he also assures me that payment would be done to DBS. So whatever discounting they have done on the strength of that Canara Bank's letter, that also is assuring me that he will repay. Finally, he ends up not paying, and DBS is wanting payment from me. So without getting the vessel, I lose my 24 crores of rupees. If this conduct is not fraud, what possibly else could fraud be? Therefore, the learned judge is right in inferring that this conduct smacks of fraud. Now, kindly see further what the learned judge says. It also appears from the pleadings and arguments of the plaintiffs that when defendant number 1 had not delivered the vessel from time to time and expected time, the plaintiff had inquired about the vessel and they came to know that the vessel was already in confiscation by Indonesian court. Thereafter, plaintiffs also came to learn that said vessel was never of the ownership of defendant number 1 at any point of time. Thus, it is clear prima facie of fraud committed by defendant number 1. When plaintiffs have made correspondence with defendant number 1 and ultimately the MOA was cancelled by virtue of the addendum 6, thus it prima facie appears that the intention of defendant number 1 was to commit fraud with the plaintiff by not delivering the vessel to the plaintiffs. Sir, my investigations have found, and I have written an elaborate letter in this regard, which I have read last time, where I have stated that how Panama registry or the Palau registry gave me this information, how that court seal was also fabricated. That letter I had last time read, so I will not repeat. But from my investigations made in October, I have found of the various suppressions which they made when the agreement was made with us. How can they sell a vessel which in the first place never belonged to them on the date of the agreement? Now, my friend is trying to argue that DBS is not supposed to make any kind of inquiries at all. And the question of title is for the buyer. With respect, no, kindly have a look at the provision of the Sale of Goods Act. The Sale of Goods Act very clearly says. Kindly see section 14 of the Sale of Goods Act. In a contract of sale, unless the circumstances of the contract are such as to show a different intention, there is an implied condition on the part of the seller that in the case of a sale, he has a right to sell the goods, and that in the case of an agreement to sell, he will have a right to sell the goods at the time when the property is to pass. His ownership is a matter of an implied condition. And there is nothing in this memorandum of agreement of April 21 to show a contrary intention. Therefore, the fraud is obvious that this defendant number 1, who was not the owner of the vessel, has attempted to sell the vessel to me. Now, the same is the provision in the Transfer of Property Act. I don't want to take your honor in detail, but section 55 of the Transfer of Property Act, in the case of sale of immovable properties, also carries the same obligation. It is with respect not possible to say that in the case of a sale and purchase of either goods, rather movables or immovables, it is the buyer who has to inquire about the title. Where is the question of me making any inquiry? He can sell only if he owns it. And if he is trying to sell something which he does not own it, in my submission, there can be no greater fraud. So the scheme of the legislature, whether your honor looks at the Sale of Goods Act, section 14, or section 55 of the Transfer of Property Act, the scheme of the legislature is very clear that so far as the title is concerned, there is an implied condition that the seller has a title to sell the property. Now, this itself was missing. This we found out in October. This man who is promising us the delivery of the vessel from April, with a promise that at the time of the sale, this would be free from encumbrances, we find that this vessel doesn't belong to him, that the vessel is subject to the arrest order of the Indonesian court, and the documents which he gives in the process are found to be fake. Now, this is a matter which seriously needs to go to trial. Now, my friend, because the answer is in the next paragraph of the learned judge's reasoning, my friend raised the question, and with an attempted innocence of the banker, what is my fault? I say that everything is your fault. How can defendant number 3 in June undertake to finance on an acceptance letter of Canara Bank when they knew that neither there is notice of readiness, neither there is establishment of ownership of the vessel, nor any indication from Mr. Azman Mohammed to defendant number 3 that they are going to honor the delivery date of 15th of June. And in retrospect, we are finding it out much later when they tell us on 22nd October. But that is besides the point. First thing is their silence from June to October. That is itself very suspicious. But I am saying that leave it aside for a moment. And let us accept that they, 1st June, we wrote to Canara Bank, 3rd June, Canara Bank wrote to DBS, and on 6th or 7th June, DBS decides to discount and make payment. The question is, what is my fault? The fault is that you are taking a risk of making a payment to defendant number 1 when the conditions of the LC are not fulfilled. Why should that risk be passed to me? What is my fault in this case? You decide to discount, although you know very well that the terms of LC are not fulfilled. The condition precedent of the letter of credit are not fulfilled. Where is that confirmation from Canara Bank that the buyer has received the notice of readiness? Let them show from 3rd June letter that Canara Bank has confirmed this. Let them show that there was a notice of readiness issued by the buyer, that the vessel had reached Alang. Nothing has happened. So in the first week of June, if a bank sitting in Singapore decides to take a risk on the strength of this kind of an imperfect letter from Canara Bank, that risk cannot be passed on to us. It is between them and defendant number 1. And with respect, but the learned judge comes up with a very credible answer to my friend's rhetorical question. What is my fault? It is in paragraph 20. Now the question is whether the fact of fraud was in the knowledge of defendant number 3 or not. Defendant number 1 was carrying his business at Singapore, and defendant number 3 is also situated at Singapore. Before discounting the letter of credit, it was the duty of defendant number 3 to inquire about that, whether defendant number 1 had delivered the vessel to the plaintiff or not. But defendant number 1 had not inquired about it. Moreover, I think what the learned judge means is defendant number 3. Moreover, defendant number 3 financed to defendant number 1 pursuant of LC. Therefore, the question arises that on what basis defendant number 3 financed to defendant number 1? Defendant number 3 has not taken any reasonable and due care before financing to defendant number 1. Therefore, it is prima facie presumed that defendant number 3 was in the by way of cross-examination of the officers of defendant number 3, why did they discount when the terms and conditions of the LC were not fulfilled? In pursuance of the MOA, at the instructions of the plaintiff, the LC was opened by defendant number 2 on 26 April. It is pertinent to note that the LC underwent changes from time to time. Looking to the opening of the LC, it transpires that it was irrevocably issued and applicable rules were UCP latest version, and beneficiary was defendant number 1. In 42C of the LC, it is mentioned by negotiation 150 days from the date of the physical delivery of the vessel and drawing Canara Bank. In column 46A, the list of documents required are mentioned, and there are total 7 documents are required in point number 7 of column 46A. It is clearly stated that the buyers have received a notice of readiness from the seller or the seller's agent at Alang that the vessel has been physically delivered to the buyer. Thereafter, in 47A, additional condition, it is mentioned in point 8 that the seller shall issue the notice of readiness for delivery only after the vessel has arrived, data safe anchorage along India, and is ready for effecting physical delivery. Thus, it clearly transpires that notice of readiness was must. So, the finding of the learned judge is that the notice of readiness was a condition of the LC. It was must. And there is absolutely nothing wrong in this finding. That is what the LC says. No doubt, LC is a contract between bank and parties are not concerned. But terms and conditions of the letter of credit is to be fulfilled and is to be respectful. And if the terms and conditions fulfilled, then LC can be encashed. Then after the LC was amended and in field 46B, point number 7 was amended as that the buyers have received a notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers and all other terms and conditions to remain the same. The plaintiffs have informed the amendment in the LC to defendant number 2. Again, LC was amended on 18/5 and LC amount was enhanced to 31 lakh so and so. It appears, looking to mark 3 upon 10, it appears that defendant number 1 wrote a letter to the plaintiffs and instructed LC point number 7 to be deleted. In additional condition 47A, following to be added, document to be presented after the receipt of an authenticated SWIFT message as under. That the buyers have received the notice of readiness from the seller or seller's agent at Alang that the vessel is ready to be delivered physically to buyers. And accordingly, it was amended. Thus, by virtue of this amendment, point number 9 was newly added, but other terms and conditions remained the same. In mark 3 upon 11 in field 46 capital A, point 7 was deleted and point 9 was added. Thus, by making all these changes, defendant number 1 wanted to encash the LC by committing fraud. Looking to the original LC, point number 7 was that the buyer has received the notice of seller or seller's agent at Alang that the vessel is ready to be physically delivered to buyers. Now it was changed in the third amended LC and point number 7 was deleted and new point number 9 was added, and the same was opening by confirming that the buyers have received the notice that the vessel is ready to be delivered. The crucial change is that in the original LC, the vessel has been delivered, while the change is vessel is ready to be delivered. Then, sir, para 22, in pursuance of the changes in the LC, defendant number 3 had sent certain documents. The learned judge has been absolutely right that only certain documents were sent. All the documents required were not sent, because notice of readiness received by the buyer, that confirmation from the Canara Bank, not as a document, but that these documents have to be presented after that confirmation notice is received. That fact is not mentioned, that we have received such a confirmation from Canara Bank. So there was a non-compliance with that condition that the documents have to be presented after the Canara Bank's notice. Certain documents such as bill of sale and certain commercial invoice, letter of undertaking, credit certificate. Therefore, on 1st June 21, plaintiffs wrote a letter to defendant number 2 regarding accepting the documents of the vessel. It is mentioned that, then I'll not read the quote. Then, on the basis of the letter written by plaintiffs to defendant number 2, defendant number 2 had sent a SWIFT message on 3rd June 21 and narrated that quote I will omit, and this document is produced at 3/14. This document, on the strength of such swift message, defendant number 3 discounted the LC in favor of defendant number 1 on 3rd June, but the plaintiffs and defendant number 2 were kept in dark about it. 22nd October, they informed as late as on 22nd October. Between June to October, defendant number 3 never informed either defendant number 2 or the plaintiff that we have discounted this LC. When, as per the amended expected date of delivery, the plaintiffs did not get the physical delivery of vessel, therefore the plaintiffs have communicated with defendant number 1 and ultimately MOA was cancelled mutually on 17th September. Thereafter, defendant number 1 wrote a letter to the plaintiff after encashing the LC, but did not inform the plaintiff about the discounting of the LC and promising to send the physical delivery of the vessel. These letters are produced at March so-and-so. Defendant number 1 informed that the process will be delayed due to lockdown by the Indonesian government. Therefore, the plaintiff wrote a letter on 15th September for cancellation of the LC. This is the first letter written by the plaintiff for cancellation of LC. It is pertinent to note that the plaintiffs were not aware about the discounting of the LC. The same was conveyed to defendant number 3 and requested to cancel the LC on 18th September. After cancellation of MOA, defendant number 1 also wrote a letter to defendant number 3 on 21st September 21 and requested for proceedings for cancellation of LC. The plaintiff again wrote a letter on 27th September to defendant number 2 for cancellation of the LC, and the addendum 6 was attached. Thereafter, on 28th September, original documents were submitted to defendant number 2 and again wrote letters on 30th September, 4th October and 5 October for cancellation of the LC. Thereafter, defendant number 2 through the swift message requested defendant number 3 for cancellation of the LC and informed that we have received a mail from your good bank informing that the cancellation is done and SWIFT will be transmitted soon. However, we have not yet received any SWIFT in return in same reference, meaning thereby that on 5 October, again defendant number 3 requested defendant number 3 for cancellation. On 14th October, Mr. Ashit Parikh, broker of defendant number 1, had informed to the plaintiff that cancellation has been completed yesterday. If so, then please to you to send us the SWIFT message received from DBS Bank as Canara Bank not received yet. Then again 14th October letter by defendant number 1 for cancellation. Now looking to Mark 3/34, which is an important document, wherein first time defendant number 3 declared that they have financed the deal upon the acceptance dated 3rd June 21 and do not agree on the cancellation of this LC. Now question is, why defendant number 3 kept silent till 22nd October? It is more than 4 months after the discounting of the LC. This fact raises serious doubts towards the conduct of defendant number 3 because defendants number 1 and 2 entered into correspondence with defendant number 3 since long for cancellation of the LC, but defendant number 3 did not reply and first time on 22nd October declared that they have financed the deal on the acceptance of the document of 3rd June. Looking to 3/34, it appears that the defendant number 3 has financed the deal only upon relying acceptance of document of 3rd June 21 and did not take care to verify whether the vessel was physically delivered or not, because it was a prime condition of the original LC and subsequent LC be physically delivered the vessel. Then after, plaintiff wrote a letter of 28 October to defendant number 1 and asked him, have he really applied to cancel the LC? And if so, how could you be so if you have received payment of the funds? Then after also wrote a letter to defendant number 2 on 28 October and informed defendant number 2 that the vessel was never any point of time of the ownership of defendant number 1. The plaintiff had returned all the documents to defendant number 2. Thereafter, on 29th October, defendant number 2 made a swift message to defendant number 3 and stated that we are surprised to receive empty number so and so from your bank stating that you have financed against the LC and do not agree to cancellation. Thus, it is very much clear that till 22nd October, defendant number 2 was not informed about the finance of the LC. The defendant number 2 was also sought date of physical delivery of vessel from defendant number 3, but it was not provided, and also informed that payment condition was not fulfilled by defendant number 1. On 30th October, defendant number 2 also made a swift message to defendant number 3 and requested to provide the date of the physical delivery of the vessel for the actual maturity date, and thereafter the plaintiff wrote a letter to defendant number 1 for cancellation of the LC. Thus, looking to all the document, it clearly appears that it was a fraud committed by defendant number 1 with the plaintiff, and defendant number 3 has financed to defendant number 1 on 3rd June merely on the strength of acceptance of documents and without confirming whether the vessel was physically delivered or not, and without confirming the terms and conditions of the LC, and without confirming the notice of readiness issued or not. With respect, the learned judge is absolutely correct in finding that defendant number 3 did not act properly and financed it without trying to verify whether that notice of readiness was delivered or not, whether the vessel was delivered or not, without anything. Only on the strength of the 3rd June letter, the defendant number 3 took a decision to finance the deal. Then the learned judge discusses. Now, herein the question is that physical delivery of vessel and notice of readiness was condition precedent of the LC or not. Looking to the LC, it clearly appears that the physical delivery of the vessel and notice of readiness were condition precedent. Defendant number 3, relying upon the document at mark so and so and the amended LC in which 46B.7 was deleted and 0.9 was added, this swift message was sent by defendant number 2 to defendant number 1 along with defendant number 3. In this document, it is very much clear that a tested telex or swift advice from the opening bank confirming that the buyers have received the notice of readiness from the seller or the seller's agent that the vessel is ready to be delivered physically to buyers with this document of mark 3/10 have been sent. Mark 3/12 is a document of defendant number 3, wherein also it is mentioned that 150 days from the date of physical delivery of the vessel was a condition, and it was a condition precedent. On the basis of this, the plaintiff wrote a letter of 1st June 21, mark 3/13, regarding accepting the document of the vessel, and on the strength of 3/13, a swift message by Canara Bank to DBS Bank, which is produced at 3/14. And when it is mentioned that the documents have been accepted, but in this message, notice of readiness and physical delivery of vessel is not mentioned. And on the strength of this message, defendant number 3 discounted the letter of credit. With respect, absolutely correct analysis of the documents and the terms and conditions of the LC. Then, sir, the learned judge proceeds to look at the documents produced by Canara Bank on page 128. And throughout this, there is a discussion as to where is the notice of readiness. If your honor will see the last paragraph on page 127, discussion starting on page 128, while appreciating the documents produced by Canara Bank, the learned judge somewhere in the middle rightly emphasizes whether the notice of readiness is delivered or not. And on page 129, I request your honor to look at the fifth line from top, 129. Therefore, the terms and conditions of the first LC is to be fulfilled. It appears that the signature of the plaintiffs were obtained. The notice of readiness was not complied. There is nothing mentioned in the letter written by the plaintiffs for unconditional acceptance of the documents. The acceptance of the documents were subject to conditions. This is the most accurate and truthful interpretation and assessment of the plaintiff's letter dated 1st June 2021. Forget perversity or a conclusion which no reasonable judge can reach. I believe that any other conclusion is impossible to reach. The conclusion which this learned trial judge has reached is the only correct and possible conclusion to reach on a prima facie stage. I am clearly writing on 1st June letter that subject to conditions. The learned judge has reproduced that letter in his order that your honor will find. Kindly go back to my letter for a moment. Which is that paragraph? 1st June letter. Your honor will find page 120, para 23.
Yes.
Just above para 23, we are accepting the documents. The same will accept by us on arrival of the ship along with the present of notice. Kindly inform the DBS Bank Singapore accordingly. The same will accept by us on arrival of ship along with the present of notice. This sentence has been rightly construed by the learned judge that this is not an unconditional acceptance. In the first place, two things. When DBS presented the documents on 28/5, it committed the breach of the LC. The breach is that Canara Bank had not sent any confirmation to them that buyer has received the notice of readiness from the seller. So the presentation itself was in breach of the terms and conditions of the LC.
Yes.
Secondly, the presentation was not complete. It was only of certain documents. That also the lower judge finds that it was a presentation of certain documents. And thirdly, the acceptance by the plaintiff was not unconditional, but it was conditional. This letter I just read before your honor. Paragraph 22, page 120. And the finding of the lower court or the learned judge on page 129, the acceptance of the documents were subject to conditions. Then, sir, kindly continue on the same page. Very important. Last 5 lines.
Yes.
Condition number 9. Am I with your honor? Condition number 9 is about timing of the presentation of the documents. Meaning thereby, if the plaintiff got the physical delivery of the vessel on 15th June, then the document is to be presented, but defendant number 2 did not comply and presented the documents on 1st June 21, and for that the plaintiff cannot be prima facie held liable. Defendant number 3 is doing the business of banking. He must be bound by this condition. It was also the duty of defendant number 3, when defendant number 1 has presented the documents before him, they have to verify that he had issued a notice of readiness or presented or not. Defendant number 3 has also to verify the documents presented by defendant number 1 and how defendant number 2 presented these documents by breach of conditions number 8 and 9. So there is a finding of the court that the presentation of documents by defendant number 3 is in breach of the terms and conditions of LC. And in my submission, this finding is absolutely correct. Condition number 9 is to be read with condition number 8, and it is very much important. It clearly stated that seller shall issue a notice of readiness for delivery only after the vessel has arrived at safe anchorage along India and is ready for effecting physical delivery. It is admitted position that notice of readiness for delivery was not issued in this case. Thus, condition number 8 and 9 are not fulfilled in the present case. In spite of that, defendant number 3 had discounted the letter of credit when defendant number 3, being a bank and engaged in a business of banking, he has to take reasonable care before dealing with the LC. But in this case, defendant number 3 presented the documents without complying conditions number 8 and 9 of the letter of credit and did not take due or reasonable care. Moreover, a physical delivery of vessels was a condition over and above condition number 8 and 9, and it is also an inbuilt condition in the letter of defendant number 3, dated 28 May 21, regarding the local delivery of the vessel. By not complying condition number 8 and 9, defendant number 3 took a business risk. When it is business of risk, then it cannot pass on to the plaintiff. The present prudent man must inquire about the physical delivery of vessel and notice of readiness, which were the prime conditions, but defendant number 3 did not inquire about it. Therefore, the conduct of defendant number 3 is also to be considered. Then my friend relied upon that UCP 600 and also relied upon that judgment of the Supreme Court of 1969. Now, 1969 dealt with some other UCP. Currently, there is some other UCP, but assuming that conditions of both the UCP are same, the learned judge very rightly finds that Canara Bank's acceptance, when it was made on 3rd June 21, what was the position? The position was that there was an agreement. Where is the one page you wanted to show me? Kindly go back for the moment in time to 3rd June. What was the position, sir? The vessel was to arrive on 15th June. Which is addendum number 3 of the memorandum of agreement, which was made on 21st May 21. Expected time of delivery 15th June, date of cancellation 22nd June. In the context of this memorandum of agreement, when the vessel was expected to be delivered by 15th June, the plaintiff wrote a letter of 1st June, still carefully saying that subject to those documents. And when Canara Bank wrote to defendant number 3, it was very clearly understood that this vessel, if delivered on time, which is 15 June, within 150 days, a maturity date of 19th November would come and the payment would be made by that date. Canara Bank has not conveyed, either directly or indirectly, that even if the vessel is not delivered, we will make payment on 19th of November. Canara Bank has not consented with DBS that conditions number 8 and 9 of the LC are waived. Therefore, sir, my respectful submission is that much is tried to be made of the 3rd June letter of Canara Bank in the context of UCP 600, that if you did not point out the discrepancy, then everything is waived. That's the condition number 16 of the UCP on which the reliance is placed. I am submitting that here the question is not of discrepancy of documents. The question is of fulfillment of the condition precedent. And the question is of complying presentation. Therefore, Your Honor may have a look at the UCP 600 before dealing with the reasoning of the learned judge. If Your Honor will see UCP 600, which my friend has relied, do you have a copy? Sir, can I pass on my copy? No, but for me, time is running out. I have to stop at 2.
Yes.
Kindly only see the definition of complying presentation. It's on the 2nd or 3rd page, Article 2. Yes. So therefore, the question is, in this case, that when defendant number 3 bank at Singapore presented these documents, was it a complying presentation? Complying presentation means a presentation that is in accordance with the terms and conditions of the credit. Your LC says that you will present the documents only after the seller has issued the notice of readiness, buyer has received it, and Canara Bank has confirmed that buyer has received it. આમાંનું કંઈ થયું નથી. So UCP 600 is not a magical formula to walk away with money from India because they are sitting in Singapore. They have to comply with UCP 600. And my submission before the learned judge was that this is not a complying presentation because the conditions of the LC are not fulfilled. And that is what the learned judge has accepted. Therefore, my friend's argument that discrepancies are vague. Discrepancies are when all documents are presented in accordance with the fulfillment of the terms and conditions of the LC. But if there are discrepancies, but if Canara Bank ignores it, then they cannot later on complain about it. But here the question is not of discrepancy. The question is of fulfillment of the conditions precedent and the timing of presentation. Your LC says that you cannot present it unless there is a confirmation from Canara Bank about the receipt of the notice of readiness. It is not there. That NOR is not there. A vessel is subject to Indonesian Supreme Court's arrest order. There is a litigation going on in the Supreme Court of Indonesia. Where is the question of seller saying, okay, the vessel is ready to be delivered? And your honor recalls, condition number 8 says that is only after the vessel has arrived at Alang that such notice has to be issued. Not while the vessel is sitting in the waters, territorial waters of Indonesia. Vessel has to arrive at Alang, then this notice of readiness can be issued. This compliance is not there. Article 7 may kindly be seen. What is the undertaking given by the issuing bank? Provided that the stipulated documents are presented to the nominated bank or to the issuing bank and that they constitute a complying presentation, the issuing bank must honor if the credit is available, provided it constitutes a complying presentation. And it has been defined in Article 2. Now, this has been dealt with by the learned judge. Kindly see the reasoning. Both the learned advocates for the parties have relied upon UCP 600. It has produced at mark so and so, wherein Article 2 defines complying presentation. In the present case, the terms and conditions of the LC were physical delivery of the vessel and presentation of notice of readiness. But these terms and conditions have not been fulfilled in this case. Therefore, the presentation of documents of defendant number 3 cannot be said to be a complying presentation. Then after Article 7C, it is stated that an issuing bank undertakes to reimburse. Here also the word complying presentation and forwarded documents are used. But defendant number 3 presented the documents in breach of conditions number 8 and 9 of the letter of credit, therefore not a complying presentation in view of Article 7C. At the time of discounting of the LC on 3rd June, defendant number 3 knew very well that the vessel is to be delivered on 15 June 21. Therefore also, he has to wait till the physical delivery of the vessel. Much before that, he discounted the LC. It is very much clear that the LC is not only for the protection of the seller, but at the same time, it is also for the protection of the buyer also. That production seems to be a typographical error. Then the prima facie case, the judgments are dealt with. Then, sir, your honor may kindly see in paragraph 29 also the learned judge further discusses this issue, factual issue of discounting and the presentation of documents. Then in paragraph 30, the learned judge deals with his Article 16 of the UCP. Discrepant documents, waiver and notice. Now kindly see how this article is dealt with by the learned judge. Thus it is very much clear that issuing bank has to inform that presentation does not comply. Here in this case, issuing bank is not informed about the non-application of presentation. Therefore, principle of waiver applied in this case. I do not agree with the arguments of the learned advocate for defendant number 3 because defendant number 3 was duty bound and has to act upon the original terms and conditions of the letter of credit. No doubt the LC is a contract between bank and not parties. and therefore it is not concerned with the parties. But before discounting the LC, defendant number 3 could have been vigilant. It was also the duty of defendant number 3 to verify the documents submitted by defendant number 1. Defendant number 3 has not verified that physical delivery was handed over or not, and also not verified that the notice of readiness was given or not. Without verifying these conditions, defendant number 3 discounted the LC. So these conditions are conditions precedents. And as per the Chalmers on the Bill of Exchange, this Chalmers is quoted in that judgment of the Supreme Court cited by my friend. As per the Chalmers on the Bills of Exchange, exact compliance with the terms of the credit is a sine qua non, meaning thereby exact compliance with the terms of the credit is to be followed by defendant number 3 before discounting the LC. It was not followed and breached by defendant number 3. Therefore, for the plaintiff may not be penalized. Then your honor may kindly go to page 141.
Yes.
Third line from top. No doubt the court must be conscious while granting injunction in bank guarantee cases, but at the same time, court must have to look that innocent person may not suffer on the fault of other parties. At this juncture, court is only deciding interim injunction application and not the final suit, and has to only see the 3 ingredients of prima facie case, balance of convenience and irreparable loss. So, sir, my respectful submission is that thereafter the learned judge proceeds to notice the various judgments cited by the parties, and the reasoning again is resumed on page 150. Paragraph 36. Keeping in mind the aforesaid principles and having considered the case of the plaintiffs, it is undisputed fact that the LC was not an unconditional one. There was a condition of physical delivery of vessel and notice of readiness is to be given by the seller. Both conditions are not fulfilled. The plaintiff has not received the physical delivery of vessel, notice of readiness from the seller. Therefore, it is clearly appears that they have defrauded, and before reaching the vessel to Alang, defendant number 3 discounted the LC without inquiring from defendant number 1 who was beneficiary, whether vessel was physically delivered or not, and notice of readiness was issued or not. When LC was conditional letter of credit, defendant number 3 has to exercise reasonable and due care before discounting the LC or making finance to defendant number 1. Therefore, facts of the judgment are relevant. And then balance of convenience. The learned judge is considering the balance of convenience in the next para on pages 152 and 153, and then grants finally the injunction. Most importantly, the second direction. The plaintiffs are hereby directed to conclude their evidence within 3 months from the date of the framing of the issues. The status of the matter is that we have filed an amendment application before the trial court, and that is pending for the purpose of hearing. Issues are not yet framed, but there is a direction to expedite the trial and to conclude it within 3 months from the date of the framing of the issues, which is perfectly possible because there won't be more than one witness from each side, and the whole thing can be concluded in 3 months. My respectful submission is that here is an exercise of discretion under Order 39, which is absolutely correct. The findings and interpretation of the LC, absolutely correct. No interference in appeal is called for. My friend argued, I am a bank, therefore I can always pay. Now, in all bank guarantee or LC matters, the other side is a bank. So if this argument is accepted, there can be no injunction at all, because every time the concerned defendant is a bank, and banks are supposed to be good. unless in those rare cases when banks pay. And we don't know what is DBS position, at least I don't know. But let us accept that it's a solvent bank. I am saying that this argument is wrong. That for a balance of convenience, kindly consider we are bank, therefore we are good. If this is accepted as an absolute principle, there can be no injunction in any matter. Then why create the trouble of carving out 3 exceptions of fraud and equity and complying with the terms and conditions of LC? No, don't worry. We are bank. Reserve Bank will issue where you finally win after 10 years. What kind of argument is this with respect? So for balance of convenience, it is wholly immaterial that they are bank. For balance of convenience, what is material is that if this money goes there, it means that the money which I have given to Canara Bank, because Canara Bank does not give bank guarantee out of thin air. They have taken 16-18 crores of rupees as fixed deposits from me. They issue bank guarantee or LC on a margin. So my FD will go. So till this suit continues in our system, going all the way up to Supreme Court, I will be deprived of that 20 crores of rupees without having a vessel. Where obviously balance of convenience is in my favor. And how are they prejudiced? The LC is there. It is only the encashment which is stopped. If finally they lose, they will recover with interest. And that is what the letter they have written. One of the emails that they have written to Canara Bank, please take out that mail. Then remember that from 19th November, we'll start charging interest. Sure, if they win, they will walk away with interest. What is the problem? Therefore, my humble submission is that all the factors are in our favor. This defendant number 1 has completely disappeared. Ex parte before your honor, not traced in Singapore, not traced anywhere, he is simply not available. Therefore, the question is that simply because defendant number 3 is a bank, that cannot become a ground to tilt the balance of convenience in their favor. Because if this logic is accepted, all banks will walk away with injunction being vacated. Therefore, the submission before your honor is that the learned judge has very rightly considered all the factors of prima facie case, balance of convenience, and irreparable loss, and no interference is called for. Now, I straight away go to judgments. So, the first judgment is Wander versus Entox. Oh.
Interest.
સાહેબ એમનો જે પેલો વ્યાજનો ઈમેલ છે ને, it is at 3/43. એમાં એ લોકો આવું લખે છે કે as the issuing bank, your good bank have provided acceptance and as such undertake to reimburse DBS Bank as nominated bank at maturity, and that the issuing bank's undertaking to reimburse a nominated bank is independent of the issuing bank's undertaking to the beneficiary. Do note that in case we do not receive payment on due date, there will be delayed payment interest from 19th November 21. They can always be compensated by interest. Now, sir, please see, I have given a judgment compilation. Have you? Sir, please see Wander versus Entox, paragraph 14.
Yes.
Sir, it is on page 733. The appeals before the division bench were against the exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principles of law regulating the grant or refusal of interlocutory injunction. An appeal against exercise of discretion is said to be an appeal on principle. Appellate courts will not reassess the material and seek to reach a conclusion different from the one reached by the court below, if the one reached by that court was reasonably possible on the material. The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the material at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court's exercise of discretion. After referring to these principles, Justice Gajendra Gadkar in so and so, these principles are well established, but as has been observed by Viscount Simon in so and so, the law as to the reversal by a court of appeal of an order made by a judge below in the exercise of his discretion is well established, and any difficulty that arises is due only to the application of well-settled principles in an individual case. The appellate judgment does not seem to defer to this principle. This has been repeatedly followed by our Supreme Courts. I will only give 2 or 3 judgments and then quickly go to other points. Sir, one is 2010, Volume 2, Supreme Court Cases 142. Paragraph 19 and 20. Federal Bank. Your Honor will find paragraph 19, last 3 lines. Unless this court comes to the conclusion that the discretion of exercise by the High Court in refusing to entertain the prayer for injunction is vitiated by an error apparent or perversity and manifest injustice has been done to it, there will be no warrant for exercise of power under Article 136. In Wander versus Entox, which is noted by the Supreme Court, and in Para 21, this Wander was reiterated in Dongre versus Whirlpool Corporation of the Supreme Court again in 1990, and a similar view in Cadila Healthcare. So this is 2010. Then Your Honor may kindly go to 2013, 9 SCC 221, the third judgment. Paragraph 20. 2013, 9 SCC 221, paragraph 20. And para 21. Your Honor finds there is a reference to Wander versus Entox, and it has been followed. And the last judgment is 2023. Volume 1, Supreme Court Cases 634. Paragraph 36 and 37. I will not detain Your Honor by reading it.
36 and 37.
Para 36 and 37. And 37. The single judge did one thing. The division bench reversed the single judge And the Supreme Court said that the division bench was wrong in reversing the single judge because division bench has not paid heed to Wander versus Antox. This is what the Supreme Court has said. Para 37. Though the learned judges of the division bench of the High Court have on more than one occasion referred to the judgment of this court in Wander, they have not even for namesake observed as to how the discretion exercised by the learned single judge was exercised arbitrarily, capriciously, or perversely. Here, the only difference was that there was an ex parte injunction granted against which appeal was there. So, bi parte hearing was still pending. In the present case, before your honor, bi parte hearing is concluded. But the judgment is cited only for the purpose of showing that Supreme Court has consistently reiterated Wander versus Antox principle. That in appellate courts, under Order 43, your honor would interfere only if your honor finds that this exercise of discretion is perverse, capricious, arbitrary, or leading to manifest injustice to the appellant. In my submission, none of these situations are there. On the contrary, this is a badly needed injunction because otherwise I am left with a situation where without the vessel, I lose 24 crores of rupees. Now, sir, my judgments which I have cited before the court, again I want to show here. These are mostly dealt with. I want your honor to look at in my judgment firstly, Hindustan Construction versus State of Bihar, 1999 Supreme Court.
Yes.
1999 volume 8 Supreme Court case.
You have what submitted before the trial court?
Yes, sir.
Bunch.
Running page આપ્યા હશે સાહેબ. Would your honor kindly go to running page number 12? સાહેબના કોપીમાં running page નથી.
Which paragraph?
Sir, in this judgment, paragraph number 9. 1999 volume 8 Supreme Court cases 436.
Yes. Yes.
What is important therefore is that the bank guarantee should be in unequivocal terms, unconditional, and recite that the amount would be paid without demur or objection and irrespective of any dispute that might have cropped up or might have been pending between the beneficiary under the bank guarantee of the person on whose behalf the guarantee was furnished. The terms of the bank guarantee are therefore extremely material. Since the bank guarantee represents an independent contract between the bank and the beneficiary, both the parties would be bound by the terms thereof. The invocation, therefore, will have to be in accordance with the terms of the bank guarantee, or else the invocation itself would be bad. So, considering whether there is fraud, whether there is spatial equity, they are secondary things. They come later. The first question which in my submission the Honorable Court would look into is whether this invocation is as per the terms of the bank guarantee. And if that terms of the bank guarantee are not fulfilled, the invocation itself is bad. That is 1999 8 SCC. And on the same lines is the judgment of the Gujarat High Court in Wires and Cables versus Waltham. paragraph 22 to 26.
Yes.
Please see, sir, paragraph 23 in particular. It is settled proposition in law that the bank guarantee should be invoked in consonance with the terms of the bank guarantee. In the case of Puri International versus National Building Construction, reported in so and so, Delhi High Court has held that the documents such as bank guarantees have to be enforced as per their terms, and the language of the instrument has always enjoyed a position of primacy. In the case of Ansal Properties reported in 1998 Delhi High Court has held that the invocation letter does not fulfill the requirements agreed in the bank guarantee for invoking the same, and as such, this performance bank guarantee has not been validly invoked. In the case of Synthetic versus Simplex, 88 Delhi, it is held that what is necessary is that there exists a special equity in favor of the plaintiff to grant of an injunction. No doubt, an obligation of the bank under the bank guarantee is absolute, but such an absolute obligation arises only if the conditions of the bond are satisfied, and if the demand made on the bank is in strict accord with its terms, and there is no element of fraud, misrepresentation, or suppression involved. But where there are allegations of fraud, misrepresentation, or suppression of facts made by the party against the beneficiary, and there is a prima facie evidence to suggest that there is some truth in these allegations, then there would possibly be no absolute bar operating against the court from granting an interim injunction restraining the bank from making payment on the basis of the bank guarantee. Similar would be the position where the demand made by the beneficiary is in violation of the condition of the bond or is not in strict accord with its terms. Keeping in view the nature of the obligation of the bank, the terms of the bank guarantee would have to be strictly construed in such cases. In the case of BSES versus Fanner, the Supreme Court has held that the rule that the bank guarantee must be honored in accordance with its terms. There are, however, two exceptions. One is fraud and another is special equity. That law I did not detain your honor. It's a very settled legal position. But I am saying that therefore there are three exceptions. Fraud and special equity are there. But the third, which is material, is that the terms of the bank guarantee enjoy a primacy and those terms must be fulfilled. In this case, the learned judge very rightly finds that the presentation of documents by defendant number 3 was in breach of those conditions precedent of the LC, and therefore it was not a compliant presentation. Even UCP 600 does not come to the help of defendant number 3. This was a fit case for injunction. We are directed to go to trial and conclude it within 3 months of the framing of the issues. And speaking for the plaintiff, we intend to take this deadline very seriously. We have no intention to take the advantage of delay, which possibly this system may offer. In fact, I am ready to suggest to my friend, where probably all may agree, that commissioner can record evidence in Ahmedabad. Everything can be done to complete the trial within 3 months. One witness from me, one witness from them, and one witness from Canara Bank, and we are done. But please don't disturb the current protection which is granted to the plaintiff, because otherwise we would be facing a kind of a bankruptcy. My friend relied on federal bank's judgment, bank's knowledge. One was that 69 Supreme Court judgment, and one was this federal bank's judgment, and the third was that judgment where Gujarat High Court was reversed by the Supreme Court. So there are 3 judgments. Sir, this federal bank's judgment, with respect, is completely different on facts. It is 2001 volume 1 SCC 663.
Yes.
Sir, in the Federal Bank case, the receipt of the goods was acknowledged by the buyer. The most different factual aspect from the present case. If Your Honor would see, therefore, the relevant facts of the Federal Court's judgment, kindly go to the important parts of the judgment. Please see paragraph 3.
Yes.
The appellant, the negotiating bank, received documents from the sellers, which included 5 delivery challans purportedly signed by the buyer's officers, acknowledging the receipt of the goods. The seller sent a bill of exchange for encashment against the LC of 2 crores taken out by the buyers. The appellant sent the bill of exchange with the endorsement of the buyers and the LC and the connected documents, including the delivery challan as received from the seller, to the issuing bank, and got the genuineness of the documents confirmed. Where is that position before Your Honor here? The negotiating bank then released rupees 1.94 crores in favor of the sellers on 25th March, but the buyers have obtained a temporary injunction against the issuing bank from honoring the LC. This has resulted in the appellate bank not being able to obtain reimbursement. The trial court and the High Court, after noting that the negotiating bank had released to the seller the above sum, upon due certification of the seller's documents, have thus precluded the negotiating bank from getting reimbursement from the issuing bank. In these facts, what the Supreme Court says now, kindly see paragraph 7. The letter of credit issued by the issuing bank on 19th February listed out various documents which had to be produced by the sellers for payment under the LC. They were described as follows. Atla documents emne raju karwana hata. Then, sir, Your Honor may kindly see paragraph 12. On the same day, 19th March 98, the seller sent a bill of exchange, technically called a draft, to its dealer at Visakhapatnam, stating as follows. At 90 days from the date of invoice, pay to the Federal Bank, Bombay, a sum of rupees 2 crores. Towards the value of the material given as below. DD and invoice number so-and-so, date number so-and-so, amount 1 crore and 1 crore, just one steel rolling. This was addressed to the seller's agent at so-and-so. Copies were sent to the purchaser plaintiff. This bill of exchange contains an endorsement purportedly signed by the vice president of the buyers, accepted for payment on maturity. So in this case, in the Federal Bank, the buyers had already accepted the bill of exchange, saying that we will make the payment on maturity. Our 1st June letter cannot be treated at par with this. The learned judge finds our 1st June letter a conditional letter. We have clearly stated that documents will be accepted when vessel at Alang and notice of readiness is there. So this cannot be compared with this. This is an unconditional acceptance, accepted for payment on maturity. It is in the view of this acceptance by the buyer that the federal bank judgment is given. This can't come to the help of my friend. Then paragraph 18. We have already stated that the bill of exchange was also sent by the sellers to the negotiating bank through the dealer. This bill was one of the documents received by the negotiating bank. It contained the two endorsements purported to have been made by or on behalf of the buyers, to which we have already made reference, and purporting to be signed by the vice president accounts of the buyers. These endorsements read as follows: accepted for the payment on maturity. We confirm having received the dispatched documents. As far as proof of delivery of the dispatched goods are concerned, the position was as follows. Among the documents accompanying the LC were the 5 invoices dated 19th February 98 and 5 delivery challans dated 19th February 98. The 5 delivery challans contained the signature of one Mr. Wagmode, who purported to sign on behalf of the buyers, and 2 of the 5 delivery challans purportedly containing the counter signature of the vice president accounts of the buyer, dated 21st February and 23rd February respectively. The office stamp of the buyer's company was found on all the 5 delivery challans. The endorsement on the delivery challans also stated that the goods were received in good condition. My submission to your honor is that when any judgment is cited by any party, plaintiff, defendant, appellant, respondent, your honor will have to certainly look at the facts of that case, because everything which flows from the language used by the honorable court is not a part of the ratio decidendi of the judgment. One fact here or there may make all the difference. Now, my friend is harping upon that part of the judgment which says that there must be a knowledge of the bank about the fraud. The question before your honor here is that here we informed Canara Bank as soon as we came to know. Kindly see document at 3/36, which is a letter of some 28 October 2021. The moment our investigations revealed fraud, we informed to Canara Bank that this is what has happened to us. Pehla to mamanu ghar ketle divo bale etle 15મી જૂન 30મી ઓગસ્ટ 15 સપ્ટેમ્બર ચાલ્યા કર્યું. પહેલા તો કોણીએ ગોળ લગાડ્યું. So we innocently believed that vessel is coming. They are taking steps. When finally we realized that there is something fishy, we entrusted the whole thing to investigation. We have found this, that this vessel did not even belong to them. The vessel was subject to Indonesian court's arrest order, and they are trying to sell this, something that doesn't belong to them. So we immediately wrote to Canara Bank. So how do they claim that bank does not have a knowledge? That's the only point on which Federal Bank has probably deviated from a long line of judgments. But Federal Bank is giving a judgment in a set of facts where delivery challans were signed by the buyers, their account department had confirmed, and there was an endorsement that the goods were received in good condition. Therefore, before the learned judge, I had given what are the distinguishing features of the Federal Bank case, which I'll just very briefly submit to your honor to show that Federal Bank cannot bind. Sir, receipt of the goods was acknowledged by the buyer in the Federal Bank case. That's the first distinguishing factor. Second is that the bill of exchange was accepted by the buyer. The third is about the bank's knowledge about the fraud, which is the part of the judgment on which reliance is placed. I am submitting that kindly look at 3/36. And we have informed the bank about this fraud. And in the Federal Bank case, when Federal Bank made a payment of 2 crores of rupees, they had received confirmation from the issuing bank that the buyer has received the goods. This confirmation was backed up by the signed delivery challenge and the Vice President account statement. It is at a later stage that they tried to come out with a case of a fraud and that Mr. Wagmode was not in the job, there is some forgery, etc. But it was at a later stage, after those documents were given, on the strength of which the Federal Bank had made the payment. In this case, no such thing has happened. Federal Bank has this DBS Bank has discounted the LC on the 3rd June letter. It is not their case that when they discounted the LC, they had inquired about either the notice of readiness or whether the vessel was actually delivered. Therefore, the learned judge rightly asked questions in the reasoning of the order and answers that DBS has not taken due and reasonable care. They have not presented the documents after complying with the terms and conditions of the LC. Therefore, this Federal Bank case is absolutely not comparable to the facts of our case. And that is what the learned judge has found also. The learned judge has dealt with the Federal Bank. Therefore, kindly have a look at this judgment. Last judgment of my friend. I'll just conclude in 2 minutes. 2016 10 Supreme Court cases 46. My friend has cited Gujarat Maritime Board, paragraph 12. An injunction against the invocation of an absolute and unconditional bank guarantee cannot be granted except in situations of egregious fraud or irretrievable injury to one of the parties concerned. This position also is no more res integra in Himadri Chemicals versus so-and-so at para 14. That is quoted. Then the next paragraph. The guarantee given by the bank to the appellant contains only the condition that in case of breach by the lead promoter, that is the first respondent of the conditions of the LOI, the appellant is free to invoke the bank guarantee and the bank should honor it without any demur, merely on a demand from Gujarat Maritime Board, stating that the lead promoter failed to perform the covenants. It has also been undertaken by the bank that such written demand from the appellant on the bank shall be conclusive, absolute, and unequivocal as regards the amounts due and payable by the bank under this guarantee. We don't have such terms. This is not an unconditional letter of credit at all. The LC itself says that please present the documents after the notice of readiness is received, while they have done it before. So this judgment also in my submission is not in any way helping my friend. Lastly, I want to cite the Supreme Court judgment. 2004, volume 8, Supreme Court cases 579. Sir, this 2004 8 SCC 579 in my submission is important as to how to construe and read an authority cited at the bar of the Supreme Court or the High Court. Sir, paragraph 9, kindly turn to paragraph 9, page 584. Courts should not place reliance on the decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Observations of the courts are neither to be read as Euclid's theorems, nor as the provisions of a statute, and that too taken out of their context. These observations must be read in the context in which they appear to have been stated. Judgments of the courts are not to be construed as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark into lengthy discussions, but the discussion is meant to explain and not to define. Judges interpret statutes, they do not interpret judgments. They interpret words of statutes, their words are not to be interpreted as statutes. Then, after quoting the English judgments, kindly see paragraph 11, circumstantial flexibility. One additional or different fact may make a world of difference between conclusions in two cases. So, Federal Bank, when it says that banks should have a knowledge of the fraud without which no injunction can be granted, that sentence of the Supreme Court, it is not to be read like a statute of parliament. Please read that sentence in the light of the facts of the Federal Bank case, where buyer had acknowledged the delivery of the goods, signed the delivery of challans, their vice president accounts had accepted the bill of exchange. In this context, they stated that when the bank discounted, they did not have the knowledge. This discounting on 3rd June or whatever June that they later on disclosed in October, this discounting takes place in a fact scenario where they are themselves in breach of the terms of LC. Therefore, the learned judge was absolutely right, and I submit that the appeal may be dismissed.
Canada Bank, issuing bank. 3 o'clock. They must use it. 36 days. એમને એટલે એને સમજાઈ કરવાનું आप कहते सर तुम शुरू करी મને વાંધો નથી other side you are for respondent number 4 respondent original defendant number 2 Canada Bank નથી nobody નો કોઈ છે નહીં સર કોઈ નથી
Let's wait for one or two.
ચોક્કસ.
Original educated on record council. Original on record. Educate on record original council. You should. You see one day. Start. Your Honor, to the judgments. Yes, sir, I am told that Mrs. Sita still wants to. Okay. Submit and send the message to you.
We can start.
Okay. Let that. Please, Your Honor.
Except before my friend starts, just 2 minutes. ચાલુ છે.
અચ્છા.
Sorry. Sir, before I conclude, my friend has also relied upon one another letter of 1st June 21, which is in their convenience compilation at item number 33.
Yes.
And my friend apparently is also suggesting that this was suppressed. Sir, my answer is only this, that there is no question of suppression of this document. On 1st June 21, I had written a letter which I have explained in my plaint. In what circumstances that broker of defendant number 1 came, and how I wrote a letter, and how it is not an unconditional acceptance. Now, this letter of 1st June 21, Your Honor will notice, is in a previously printed format of Canara Bank. And one particular part is in fact even blank. Particularly, Your Honor will see number 2, confirm the due date of bill as. It's a blank date. Even in the reference, advance bill number so and so is blank. The submission is that this acceptance letter of the plaintiff also does not advance the case of defendant number 3. Because in this acceptance letter, there is no indication that those conditions number 8 and 9 of the LC are waived. I do not say while signing this letter that you can present the documents without complying with the terms and conditions of the LC. Therefore, to claim that this second letter of 1st June is a departure from my other 1st June letter, and there is unconditional acceptance of all the documents and waiver of the rest of the conditions, that is not supported by this 1st June letter. So my submission is that whichever 1st June letter that your honor would look at, 1st June letter of the one which I have explained in the plaint, or this 1st June letter, none of these letters show that the plaintiff agreed that the terms of LC are not required to be complied with. And even this is a letter between me and Canara Bank basically. Canara Bank is also not claiming that because of this 1st June letter, we were justified in issuing the letter of 3rd June 21. That is not even the case of Canara Bank. Canara Bank has also very clearly written to DBS Bank later on that maturity date of 19th November was a tentative maturity date. It was conditional upon all the conditions being fulfilled. Physical delivery of the vessel, 42C, notice of readiness, and other conditions of LC. Therefore, this 1st June letter, which is a document between me and Canara Bank, that document can't be relied upon by defendant number 3 to say that injunction should be vacated. Because this letter also does not absolve them from the responsibility to be careful, from the responsibility to ensure the compliance with the terms and conditions of LC. Therefore, in my humble submission, this appeal requires to be dismissed. Obliged.
I'm appealing for Canara Bank. Before I take your honor to the judgments, comparison days before your honor, I would just like to recapitulate some dates, which my both learned senior friends have extensively argued before your lawsuits. The last amendment in the LC is of 24th May 2021. The original LC is of 26th April 2021. Original LC opened 26th April 2021. The last third change in the LC was done on 24th May 2021. There are 2 letters from the plaintiff to Canara Bank, one produced by them in the plaint, one produced by me in the written statement. Then there's a 3rd June swift message from Canara Bank to DBS, which is the core contention about the interpretation, 3rd June 2021. 18th September 2021, Canara Bank, respondent number 4, before your honor, original defendant number 2, writes to DBS Bank for cancellation of LC for the first time, 18th September 2021. And on 21st and on 22nd October 2021, original defendant number 3, DBS Bank, tells to Canara Bank for the first time that they have financed upon the LC, discounted the LC. The date is not given, what Mr. Sukla extensively argued on that point. But they have financed upon the LC. For the first time it comes on record by way of 22nd October 2021. Later on, in the pleadings of the High Court, what I understand, the date comes 6 or 7 June 2021, DBS Bank discounted the LC. I am Canara Bank, I am the issuing bank. Hussain Ispat, the plaintiff before the trial court, is the applicant. It is at their request I opened the LC. Capital Corp was the seller. They are the buyer. What seller's bank is the DBS bank. Now, kindly appreciate, Your Honor, how it works. They approached me, kindly open an LC. So what was going to be my involvement? As a bank, I would get LC opening charge. If I open an LC, issue an LC, I become an issuing bank, I get LC opening charge. Similarly, DBS bank is a collecting bank. For the seller, he will be getting some collection charge from the seller. But as a chain of events unfold, they have discounted the LC. The LC was for 31,58,000 an odd amount US dollars. They discounted it on 6 or 7 June for 31,11,000 US dollars. Rather than being a collecting bank, they thought it fit. Their wisdom, they can do it. They discounted the LC on 6th or 7th June. Now the issues before Your Honor are whether the presentation is proper or not. One, whether if presentation is proper, then another issue which the plaintiff has argued before Your Honor is whether any fraud is played upon them or not, and whether if fraud is there, whether proper pleadings are there, and whether proper assertions are there in the pleadings, because fraud is the evil of the evils. But anyone may come and argue that there is a fraud. Ultimately, there has to be edifice, basis of the fraud. In this backdrop, I would like to take Your Honor to some judgments which I am relying upon. The first judgment in my compilation is Bava Paulins, the latest judgment of the Supreme Court versus UPS Freight Services India Private Limited. In my compilation, which starts from page 1, the relevance for my purpose is para 34 on page 7. Page 7, para 34. I am with Your Honor on page 7, para 34. It is common knowledge that in international transactions, letter of credit is used as a mode of ensuring payment and performance of the contractual terms. A letter of credit is a document issued by the bank, issuing bank on behalf of a party, applicant in favor of another party, that is a seller, Capital Corp in our case, under which the issuing bank undertakes to pay to the beneficiary. The beneficiary was defendant number 1, Capital Corp. Certain sums of money subject to compliance of the terms and conditions of the letter of credit. In an international transaction, the beneficiary is the seller who requests the applicant buyer to furnish a letter of credit from any bank. In this case, Canara Bank, which is recognized worldwide issuing bank. The letter of credit is issued in favor of a beneficiary on the request of an applicant after furnishing securities as may be demanded by the issuing bank. A seller, which defendant number 1 before the trial court, can ask the issuing bank to honor the letter of credit to his own bank, confirming bank within a certain maturity date. Here the maturity date is 19th November, in our case 2021. The seller is required to produce certain documents regarding proof of delivery of goods, commercial invoice, bill of lading, insurance documents, etc. before the confirming bank. So Capital Corp will approach the DBS bank. On scrutiny, the confirming bank would ask for advice of the issuing bank to confirm whether documents produced by the beneficiary is compliant with the terms and conditions of the letter of credit. Once the issuing bank, this is very important, the purpose of law point. Once the issuing bank confirms the document, the confirming bank is obligated to pay to the beneficiary. So in our case, DBS has to pay to Capital Corp on demand the credit amount and in turn recover the same from the issuing bank. This is basically long and short the law of LC, but it doesn't cover or envisage the exception, that is fraud. This is basically the long and short of the what is the law of LC, how it works out. So once I confirm, they will pay to the seller and then I have to pay them, unless and until I am obligated to pay to them unless until I am injuncted by any competent court. In the case on hand, the learned trial court has injuncted me. Because of injunction, I am not paying to TBS Bank. Moving forward, the second judgment. The second judgment on page 10, 2015, volume 14 SCC, page 375, Millennium Wires Private Limited. For my purpose, relevant is para 9 to 11 on page 15. If your honor may oblige me by turning to page 15, para 9, my lords. Nothing in the plaint except the above two extracts has even come close to being an allegation against the negotiating bank. In the above two extracts, there is expression of mere apprehensions of the plaintiffs that the negotiating bank was in active collusion with synergy companies. No explanation or justification has been made in the plaint as to how this active collusion came about or what makes the plaintiff suspect so. It is true that in plaint, not all the evidence with respect to the allegations is to be adduced. However, a comprehensive narration of facts that constitute the cause of action has to be given in the plaint. It is plain and clear that no cause of action whatsoever may be deduced against the negotiating bank from the above two extracts which form part of the plaint. Furthermore, both the single judge and the division bench have discussed the law relating to letter of credit and UPC 600 in great detail. In view of that, the following observations of the court in RD Harbottle, so and so, Queen's Bench. I may take you on to the next page. Banks must be allowed to honor their guarantees without interference, except, this is a rider, in clear cases of notice of fraud to the bank. So here the plaintiff has to prove the notice of fraud to the bank. That's the law. The merchants take risks which are not to be imposed on the banks. Such interference will deter trust in international commerce. And para 11. We would uphold and restate the law on injunction against honoring letter of credit by a bank as summed up by the learned single judge as follows. 11.1. The court must be slow in granting an order of injunction restraining the realization of bank guarantee or letter of credit. But in the case on hand, there is an injunction and your honor is hearing the appeal. So some different parameters may apply as far as appellate court is concerned. There are two exceptions to the above rule. The first is that it must be clearly shown that a fraud of a grievous nature has been committed and to the notice of the bank. The second is that injustice of the kind which would make it impossible for the guarantor to reimburse himself or would result in irreparable harm or injustice to one of the parties concerned should have resulted. It is not enough to allege fraud, but there must be clear evidence both as to the fact of fraud as well as bank's knowledge of such fraud. Well, it would suffice to say here that injunctions against the negotiating banks for making payments to the beneficiary must be given cautiously, as constant judicial interference in the normal practices of market can have disastrous consequences as it affects the trustworthiness of the Indian banks and markets. With this, I may take your honor to the third judgment on page 17, Himadri, para 14 on page 24. Page 24, para 14. From the discussions made herein above, relating to the principles for grant or refusal to grant an injunction to restrain enforcement of a bank guarantee or letter of credit, we find that the following principles should be noted in the matter of injunction to restrain the encashment of a bank guarantee or letter of credit. While dealing with an application for injunction in the course of commercial dealings, and when an unconditional bank guarantee or letter of credit is given or accepted, the beneficiary is entitled to realize such a bank guarantee or letter of credit in terms thereof, irrespective of any pending disputes, relating to terms of the contract. 2. The bank giving such guarantee is bound to honor it as per its terms, irrespective of any dispute raised by its customer. 3. The court should be slow in granting an order of injunction to restrain the realization of bank guarantee or letter of credit. Since a bank guarantee or letter of credit is an independent and separate contract and is absolute in nature, the existence of any dispute between the parties to the contract is not a ground for issuing an order of injunction to restrain the enforcement of bank guarantee or letters of credit. 5. Fraud of an egregious nature which would vitiate the very foundation of such a bank guarantee or letter of credit and the beneficiary seeks to take advantage of the situation. 6. Allowing encashment of an unconditional bank guarantee or a letter of credit would result in irretrievable harm or injustice to one of the parties concerned. I am not taking your honor to Federal Bank. Much has been argued by both the sides, so I don't wish to comment anything on the Federal Bank. I may take your honor to Madras High Court, where one injunction was granted on page 56. In the comparison, page 56, the judgment starts, for my purpose, relevant is page 66, my lords. 66, just above para 16 on page 66. Yes. If I am with your honor, just above para 16, 4 lines from the bottom of para 15, if these principles of law settled by the apex court in the above cited decision are applied, this court is of the considered opinion that it is a fit case where the court has to grant an interim injunction for the following reasons. Admittedly, the materials have not been actually delivered by the appellant to the first respondent, and also they are in the custody of the appellant / first defendant. The case of the appellant is that it is true that it was not delivered because there was a refusal to take delivery of the materials by the first respondent / plaintiff when an attempt was made. After looking into the materials available and in particular the letter of credit dated so and so and the other circumstances, this court is of the view that the appellant / first defendant is not entitled to negotiate the letter of credit in question. It is true that the delivery or non-delivery of the material is actually a dispute which exists between the appellant and the first respondent. It is the buyer and the seller. And hence it cannot be a ground for issuing an order of injunction to restrain the enforcement of letter of credit, since the letter of credit is a question. In question is an independent and separate contract between the appellant and his banker. Under such circumstances, as to the question of delivery, the parties will have their recourse open against each other. But in the case on hand, the appellant beneficiary is not entitled to realize the letter of credit since the appellant has not acted in terms of the letter of credit. The irrevocable letter of credit relied on by the appellant is filed at so and so, dated so and so. Inter alia clause 7 of the letter of credit imposes other conditions. Clause so and so reads, delivery at so and so port project site. Hence, before the letter of credit in question was to be negotiated by the appellant, one among the conditions imposed was a delivery of the material at so and so port project site. In the instant case, admittedly, it was not done. It could be seen that for the negotiation of the letter of credit through irrevocable, the delivery of the materials is shown as condition precedent, and without satisfying that condition, the appellant is not required to negotiate or encase the letter of credit in question. As per the above settled principles of law by the apex court, a beneficiary is entitled to realize the letter of credit in terms thereof, but not otherwise. In the case on hand, the appellant beneficiary is not entitled to realize the letter of credit since he has not acted in terms thereof by performing the condition as found in the letter of credit itself, namely clause so and so, and hence the dispute relating to the delivery of materials between the parties has nothing to do with the above terms found in the letter of credit. So I am able to lay my hands on one judgment of the High Court where the injunction was granted. Moving further, on page 60 is one article.
Page 60?
68. Which succinctly depicts and reflects the principles governing the letter of credit. I would just like to read some few paragraphs with your honor's permission. Page 68, the first paragraph. The doctrine of autonomy is one of the foundation stones of the law of letter of credit. Under this doctrine, the obligation of an issuing bank
judgments we can understand the articles of certain or personal views.
But ultimately, it's not the view, the judgments of the American courts and English.
Can we have judgments of our High Court, our Supreme Court for the articles that
I mean, just read my honest.
extremely well separate on that.
I would say still evolving. The doctrine of autonomy is one of the foundation stones of the law of letter of credit. Under this doctrine, the obligation of an issuing bank of a letter of credit is independent from the underlying sale of goods, contract for which the credit will provide payment. An exception to this doctrine may arise in case of fraud. Under the fraud rule, although the documents presented may comply strictly on their face with the terms and conditions of the letter of credit, payment under the credit may be stopped if fraud is found to have been committed before payment is made, provided the presenter or party demanding payment does not belong to a protected class. And if Your Honor may oblige me by turning to page 81. The catalyst, the Steen case. Steen is the landmark case in the course of the development of the fraud rule in the law of letters of credit. It has not only been codified in the Uniform Commercial Code and followed by nearly all subsequent letter of credit fraud rules in the United States, but has also been cited with approval or followed throughout the common law world. Because of its significance, special treatment of the case is warranted. I may then take Your Honor to next page, page 82. For my purpose, the relevant is, I may directly jump to page 83. With Your Honor's permission, page 83, somewhere in the middle. The judge then succinctly, page 83, somewhere in the middle, the judge then succinctly laid down the reasons for deciding in a way that might have seemed contrary to this principle by saying, of course, the application presupposes that the documents accompanying the draft are genuine and conforms in terms to the requirements of the letter of credit. However, I believe that a different situation is presented in the instant action. This is not a controversy between the buyer and seller concerning a mere breach of warranty regarding the quality of the merchandise on the present motion. It must be assumed that the seller has intentionally failed to ship any goods ordered by the buyer. In such a situation, where the seller's fraud has been called to the bank's attention before the drafts and documents have been presented for payment, the principle of independence of the bank's obligation under a letter of credit should not be extended to protect the unscrupulous seller. And on the next page, page 84, the first paragraph, in what has come to be a highly regarded judgment, justice not only established the basis upon which the payment under letter of credit in the case should be stopped, but also weighed the interest of the other parties involved in the case, the issuing bank and the presenting bank. He recognized that the fraudulent actions of the seller might also work to the detriment of the issuing bank's security interest. And I may just skip the one portion, and then as for the, on the same page, as for the position of the presenting bank, the chartered bank, Justice so-and-so observed, no hardship will be caused by permitting the bank to refuse payment where fraud is claimed, where the merchandise is not merely inferior in quality, but consists of worthless rubbish, where the draft and the accompanying documents are in the hands of one who stands in the same position as the fraudulent seller, where the bank has been given notice of the fraud before being presented with the drafts and documents for the payment, and where the bank itself does not wish to pay pending an adjudication of the rights and obligations of other parties. Next page, on page 85. On this motion, only the complaint is before me, and I am bound by this allegation that the chartered bank is not a holder in due course, but is a mere agent for collection for the account of the seller charged with fraud. And with Your Honor's permission, I will just take to the last page, page 116, conclusion. Page 116, para 10, conclusion. The fraud rule is an integral part of the law governing letters of credit and was developed to fill a gap in that law to prevent unscrupulous beneficiaries from abusing the letter of credit system and defrauding the applicant and the insurer. And with Your Honor's permission, I would like to take Your Honor to the Federal Bank judgment on page 28. page 20 of the comparison federal bank judgment argued by both the sides. I would like to take your honor to para 57 on page 35. No, that is my apologies, that is wrong. Just correct my page number. Page 50, page 50, para 57. Yes, page 50, para 57. Care Justice said in Hardy Harbottle that irrevocable letters of credit are the lifeblood of international commerce. He said, except possibly in cases, clear cases of fraud of which the banks have notice, the courts will leave the merchants to settle the disputes under the contracts by litigation or arbitration. Otherwise, trust in international commerce would be irreparably damaged. Tanning Master of Rolls, Tanning MR, stated in so and so that the only exception is where there is a clear fraud of which the bank had notice. Brown, Lord Justice, said in the same case, but it is certainly not enough to allege fraud. It must be established, and in such circumstances, I should say, very clearly established. In so and so, it was said, where it is proved that the bank knows that any demand for payment already made or which may thereafter be made will clearly be fraudulent, but the evidence must be clear, both as to the fact of fraud and as to the bank's knowledge. It would certainly not normally be sufficient that this rests on the uncorroborated statement of the customer, for irreparable damage can be done to a bank's credit in the relatively brief time before the injunction is vacated. Thus, not only must fraud be clearly proved, but so far as the bank is concerned, it must prove that it had knowledge of the fraud. In so and so, it was stated that there must be proof of knowledge of fraud on the part of the bank at any time before payment. It was observed that it would be sufficient if the corroborated evidence of the plaintiff, usually in the form of contemporary documents, and the unexplained failure of a beneficiary to respond to the attack lead to the conclusion that the only realistic inference to draw was fraud. Okay, I may just skip one more paragraph and direct jump to paragraph 58, the same page. The foundation of English law in this area was the American case of so and so, which also I read from my notes. This case has been cited in more than one judgment of this court and the English courts, but we shall give more facts of that case and the principle of holder in due course laid down therein, which arises in the case before us. As per the appellant's pleadings, in that case, the appellant for a credit claimed injunction against the issuing bank, Schroeder Banking Corporation, to prevent it paying on the documents which had been presented. The credit had been advised to the seller in India by the issuing bank's correspondent in India, Chartered Bank of India, Australia, and China. The correspondent had not confirmed the credit. The applicant alleged that what had been shipped was rubbish rather than results contracted to be supplied. Chartered Bank, the collecting bank, which received the documents from the seller for collection, applied for dismissing the buyer's claim. This was a proceeding similar to Order 7, Rule 11 CPC, for an injunction on the ground that there was no cause of action. The buyers in their application for injunction informed the issuing bank about the fraud of the sellers. For the purpose of hearing that application of the collecting bank, the court assumed the facts stated in the application of the buyer as to fraud to be true. Where the seller's fraud has been called to the bank's attention before the drafts and documents have been presented for payment, the principle of independence of the bank's obligation under letter of credit should not be extended to protect the unscrupulous seller. It is true that even though the documents are forged or fraudulent, if the issuing bank has already paid the draft before receiving notice of the seller's fraud, it will be protected if it exercises reasonable diligence before making such payment. The facts as stated above were that the sellers had drawn the draft under the letter of credit to the order of Chartered Bank of India, Australia, and China, and delivered the draft and the fraudulent documents to the said Chartered Bank's branch at Concord for collection on account of the sellers. Chartered Bank could not compel the issuing bank, Schroeder Banking Corporation, to pay by seeking a dismissal of the buyer's application by way of a demur. The plaintiff was entitled to injunction, for it had brought the allegation to the knowledge of the issuing bank before the payment was made. Justice so and so further observed, as one court has stated, obviously when the issuer of a letter of credit knows that the document, although correct in form, is in point of fact false or illegal, we cannot be called upon to recognize such a document as complying with the terms of the letter of credit. No hardship will be caused by permitting the bank to refuse the payment where frauds is claimed, where the merchandise is not merely inferior in quality, but consists of worthless rubbish. The draft and the accompanying document are in the hands of one who stands in the same position as the fraudulent seller, where the bank has been given notice of fraud before being presented with the draft and documents for payment, and where the bank itself does not wish to pay pending an adjudication of the rights and obligations of the other parties. Today, my position is I am injuncted by the order of a trial court. If the stay is vacated, I have to pay. Today, in the plaint also, there is some allegation in the plaint by the plaintiff against Canara Bank. When my learned senior friend argued, he also made some remarks about Canara Bank. Ultimately, I am the issuing bank. If today the stay is vacated, I am bound to pay. Today, ultimately, this is where the factual position is. And there are two letters of 1st June and there is a 3rd June message, swift message from Canara Bank to DBS. On 6th or 7th June, they discounted the LC, but they informed Canara Bank only on 22nd October 2021. And I had informed DBS Bank on 18th September 2021 about the intention to cancel the LC. These are the broad facts, and this is my stand. Obliged.
A very, to say the least, a strange stand taken up by the Canara Bank. Canara Bank has to answer what did it convey on 1st and 3rd June. Now, this is something my learned friend says orally. A lot has been argued by the plaintiff, a lot has been argued by the Canara Bank. Let us see the pleadings. Because first and foremost, I'll deal with the submissions of Canara Bank. Kindly have a look at para 6 of his written statement. This kind of stand obviously to support the plaintiff, if not openly, in a very implicit manner.
WS of the Canara Bank.
WS of the Canara Bank.
Exhibit 26.
Yes. Now, Your Honor, may kindly see, to begin with, sir, the earlier paragraphs they deny and they dispute the correctness of abovements. So I'm not taking Your Honor to all that. Please see paragraph 11. The factual aspect, position of the under dispute as per the record maintained by answering defendant number 2.
Yes.
Are as under. Then in para A, they refer to the memorandum of agreement. Then there is a factual narrative of how the LCs were amended, etc. We are concerned with paragraph. We are concerned with paragraph 11A, first of all. Yeah. Let me take it out from my compilation. The plaintiff entered into a memorandum of agreement with the, I am on paragraph 11A, with the defendant number 1 for purchase of vessel, and accordingly, the plaintiff approached the answering defendant number 2 to open the letter of credit. Answering defendant number 2 with a swift message dated 26/4/2021 confirmed that this is all the factual narrative. I think we can skip that and take Your Honor straight away to the relevant paragraph on these two letters of 1st June and 3rd June, which Your Honor will find in para C. Yes. The plaintiff with a letter dated 1/6/2021 informed to the defendant number 2 that they are accepting the documents. The same will be accepted by them on arrival of the ship along with the notice of readiness. So this is their understanding of the letter of 1st June. It submitted that as per the letter dated 1st June 2021, along with the addendum number 3, it is transpired that the ship is about to arrive on 15/6/2021. Accordingly, the defendant number 2 informed the defendant number 3 with a swift message dated 3/6/2021 and that the documents have been accepted. Please note this, sir. This is very crucial because lot turns on this. My learned friends' arguments as well as Canara Bank's arguments will get answered. What did they convey? Accordingly, the defendant number 2 informed the defendant number 3 with a swift message of 3/6/2021 that the documents have been accepted and the amount of letter of credit will be paid on 19/11/2021, assuming, please note the use of the word, assuming that the delivery of the vessel and the notice of readiness, etc., will be provided on or before 22/6/2021 as per the terms and conditions of the letter of credit, and the copy of the said swift message was also forwarded to the plaintiff as per procedure and not disputed by the plaintiff. The copy of the aforesaid documents are attached with separate list. You know, lot of communication obviously must have taken place between the plaintiff and the defendant number 1, capital call. We are not privy to it. There is correspondence which has taken place between the defendant number 1, a plaintiff, and Canara Bank, to which also we are not privy. Nonetheless, the plaintiff comes with a case that we had no knowledge. Defendant number Canara Bank says this swift message was also forwarded to the plaintiff. So the 3rd June swift message is forwarded to the plaintiff is what Canara Bank is saying. According to me, the entire matter turns on these 2 swift messages. We are not supposed to get into the other issues at all. Since my learned friend has raised those issues, I'll answer each one of them very briefly. But the fact of the matter is, if your honor takes an overview of the matter, that there is an agreement for transfer sale of a vessel. We are not concerned with that agreement at all. I am the nominated bank, I am the negotiating bank. Whether the plaintiff at the relevant time when they entered into this agreement had knowledge of the fact that the vessel which is to be sold is embroiled in litigation or not, we do not know, and we are not concerned. They today very conveniently claim that we are not aware about any of this. I will show from the correspondence that this is not correct. They were aware, and if you go by the pleadings in the plain, what is argued by my learned friend is completely contrary to the pleadings in the plain. But that apart. So there is an agreement. There are amendments to the agreement, corresponding amendments to the letters of credit. We are shifting conditions from A to B, etc. Because all those things we have show to the honorable court that what exactly transpired over a period of time. But what actually really requires to be seen and answered is this, that have I acted in accordance with the letter of credit read with the UCP? That is the only inquiry. If we see the arguments and if we see the law which is cited by both my learned friends, the courts have said that so long as the presentation is in accordance with the terms of the letter of credit, and when the terms of the letter of credit specifically incorporate by reference the UCP, then if it is in accordance with the UCP, then the bank is entitled to the payment because I have acted to my prejudice. So what is to be seen is what actually transpired on 1st and 3rd June. That is all that has to be seen, because on 7th June, I have already acted to my prejudice by releasing the payment to capital call. So if I have done it with the concurrence of the plaintiff and or, because I am again saying, I am not supposed to obtain concurrence of the plaintiff at all. I am supposed to obtain concurrence of Canara Bank. So if I have released the payment to capital call with the concurrence of Canara Bank, can that amount be retained by Canara Bank, or would the Canara Bank be obliged to pay? Now today we are at the interim stage. Ultimately, the matter is required to be tried. It is argued as if this is a stage for conclusively establishing fraud. It is not. What is to be seen is whether I have negotiated in accordance with the LC whether I have negotiated in accordance with UCP. Now, my learned friend for the plaintiff argued the entire matter as if 3rd June, the 1st June second letter, no, there are 2 letters on 1st June, as if the 1st June second letter does not exist at all. All his submissions are, they proceeded on the basis, and subsequently, at the fag end of the arguments, he deals with the 1st June second letter, saying that this is in a printed format, etc. Now, whether at this stage of interim relief, can I be denied the payment on such a lame ground, where a plaintiff discards an inconvenient document saying that it is in a printed format, there are blanks, they have been filled up, this document does not in any manner work to the advantage of, these are not, in my respectful submission, this is not the stage at which so all that I have to show to your honor is that there is a payment made by me with the concurrence of the issuing bank. That is all that I am supposed to show to your honor. The moment I show to your honor that I have made that payment, and it's unfortunate, Canara Bank should very clearly come out with a stand. What Canara Bank has done in the arguments is contrary to the pleadings. In the pleadings, they very clearly dispute and deny the suit of the plaintiff. They say that every amendment made in the plaint is incorrect. But today, standing before your honor, they first of all show the law, and then they say that if ultimately your honor tells me I'll pay, but what is your stand? Have you not given me concurrence for the payment or not? Your written statement seems to say that yes, that concurrence is given. So why can't my learned friend not say in terms of his written statement that concurrence has been given? But that is not happening. The collusion is apparent. So because what is actually happening is this, that the plaintiff enters into this agreement for purchase of a vessel, knowing fully well that this vessel has some issues. And because we all know, whoever has dealt with such matters, there are always issues involving a vessel, which basically comes for the purpose of breaking. This is also a vessel which is coming to Alang for the purpose of breaking. So a purchaser of a vessel for breaking is aware about the fact, and these are people who are in the business. To conveniently say that we had no knowledge of this, etc., is on the face of it unbelievable. And it is something which calls for a trial. And at the trial, the plaintiff will have to be cross-examined on this. But the point of the matter is that you enter into a contract, you are aware about the problems with the vessel, you agree upon a certain date of delivery, you open a letter of credit. Now, when the vessel, you realize that the vessel is not getting released, and you realize that the defendant number 1 wants funds for the purpose of release of the vessel, you work out an arrangement whereby the letter of credit is negotiated on the strength of the documents which are available with Capital Corp. And once the letter of credit is negotiated on the basis of that strength, those letters, Capital Corp receives the money. That money was utilized by Capital Corp for the purpose of getting the vessel released. At some stage, you realize that it is not happening. So you say we are terminating. And because what is very important is this, that if you are of the view that Capital Corp has committed a fraud with me, you will not terminate the contract, recording that either side will have no claim against the other. So you are terminating the contract in a case where you are today pleading fraud. Because you are today pleading fraud because you want to deny money to me. But if it was actually a case of fraud, can somebody who is a victim of, would somebody who is a victim of fraud say that yes, we are terminating the contract without reference to kindly have a look at that document? Because this in my respectful submission talks volumes about the manner in which the entire case has been, this entire suit has been engineered. Your Honor may kindly see, sir, my compilation, page 38. On 17th September 2021, because I will read this and thereafter read the plaint. 17th September 2021, this is what they write. Second paragraph. Accordingly, we hereby cancel the MOA dated 21st April 2021 and addendum number 5, showing date of cancellation as 6th October 2021. Due to this cancellation, it is mutually agreed that either buyer and seller have no claim against each other, and seller is free to sell the vessel to any party. Sir, if you are a victim of fraud, would you ever agree to these terms? Now, my friend's pleadings may kindly be seen. This entire argument of fraud, please see how it conveniently keeps on improving. Let's go to para 25 of this appeal paper book, where paragraph 11 I have read in the past, but I will just to
This
para 25, para 11. Thereafter, Mr. Ashit Parikh, Your Honor has it, approached plaintiff number 2 and conveyed that said vessel was about to sail and reach Alang on 22nd June 2021, as promised by defendant number 1 and duly recorded in the third addendum to the MOA. He further conveyed that defendant number 1 needed a letter from the plaintiff to enable him to secure the early release of the said vessel. Now, I was pausing here for a moment. The vessel, as my learned friend points out, is attached by some order of the Indonesian Supreme Court or whatever. So it is under attachment. How will the plaintiff's letter help the seller, Capital Corp, in getting the vessel released? We do not know. But they said that Ashit Parikh approached us for the purpose of obtaining a letter. So, Milords, obviously, because money was required by Capital Corp for the purpose of getting the vessel released, it was conveyed by Capital Corp that please ensure that the money comes to us so that we can get the vessel released. And therefore, now reading further, he also conveyed that such letter will not create any further liability for the plaintiffs and that the plaintiffs would be required to pay only as per the terms and conditions of the letter of credit. With his help and according to his instructions, the plaintiff addressed a letter to defendant number 2, the draft of which was actually dictated by Ashit Parikh on 1st June 2021. In the said letter, it was stated as follows. Now, this letter is the bone of contention. My learned friend says that the English, we are not on English, because the language, ultimately, what is it being conveyed? That is being conveyed, we'll have to be seen. We are accepting the documents. So very first, in fact, there should be a full stop, but let's take it, there is a comma. The same will accept by us on arrival of ship, along with present of notice of readiness, kindly inform the DBS Bank Singapore accordingly. Now, please consider this. The background in which the letter is written, as explained in the plaint, we are ultimately at the end of the day regulated by the pleadings between the parties. So the pleading with which the plaintiff comes to court is this, that the vessel, it will help, a letter from you will help us in getting the vessel released. And they write this letter without explaining as to how the contents of this letter will help them in getting the vessel released from the Indonesian court. So, because they have issued a letter, they are mindful of that. They are also mindful of the fact, and that is where my argument of a very, very serious argument of suppression comes in, that they are mindful, sir, when they disclose this letter of 1st June to Your Honor before the trial court in the plaint, were they not obliged also to disclose that format letter of 1st June? They have issued it. They have signed it. Today also it is not being disputed that it is not our signature. It is not being contended before Your Honor that it's not our signature. So they have signed it. They don't disclose it. They give a spin to this letter of 1st June saying that it is for some altogether a different purpose. The fact of the matter is that 1st June a letter is written. Now, I was reading further. From such letter, it is clear that the plaintiffs conveyed that the documents are in order and we are intending to and will accept them when the ship has arrived at Alang and when the notice of readiness is presented. So now they give a different interpretation. They improve the language of the letter and they say that this is what we had actually intended to convey by this letter. Now, because all this they want Your Honor to accept at the interim stage, because the point is that if there is a letter of 2 letters of 1st June and there is a swift message of Canara Bank, can the money ever be denied to me? The matter should rest there. Because all these arguments about fraud, this, that, etc., and there are answers to that. But are they really relevant for today's purposes? The law on bank guarantee, as has been cited by both the sides, is very clear that injunction should be rare and only the circumstances in which an injunction is. So, therefore, you come out with this argument of fraud, etc. But really, is there a fraud? That is something with the trial court. Prima facie, I am trying to say that it's not even a case of fraud. Now, please see further. The letter dated 1/6/2021, written by plaintiff, conveys beyond any reasonable doubt that the plaintiff intended to and will accept the documents when the ship has arrived at Alang and when the notice of readiness is presented. Now, pause here for a moment, and Your Honor at this stage may read the format letter of 1st June, which I am relying upon with this. Whether this interpretation of 1st June Nani?
33.
Yes, page 33. I am obliged to Your Honor. Now, is this interpretation ever possible with these documents? Let us read this closely. This bears, first of all, subject, the LC number is given. This bears reference to the documents received under import letter of credit established by you, covering import of vessel as detailed above. And in this regard, we hereby tender our acceptance of documents drawn under subject LC without reservations. Please note the use of the words without reservation. So we are not making an issue of the absence of notice of readiness or the fact that the vessel is not delivered. Without reservations. Confirm the due date of bill as so and so. We are not. Undertake to submit all the necessary documents to ensure transfer of funds. And this is important. Undertake to make payment on due date and authorize you to debit our account on the due date the counter value of the bill amount together with interest and such other charges incidental thereto. This acceptance letter given by us is in continuation of our FLC agreement, come application executed while establishing the letter of credit. Sir, normally what happens is that when a letter of credit is opened with a credit period, ultimately the person who is opening, the applicant, in this case the plaintiff, is entitled to a credit period. So when it talks about a 150-day credit period, it's a facility which if I am a businessman, then I'll have this facility with the bank, where the bank will on my documents will issue a letter of credit for the benefit of a third party from whom I'm purchasing goods, to whom I'm to pay money, and will give me a credit period. So when the letter of credit says 150 days credit period, it means that though the beneficiary is receiving the amount under the letter of credit, I as the applicant, here in this case the plaintiff, will be liable to pay to his banker only after 150 days. So therefore, in that context, in paragraph number Roman 4, he says they undertake to make payment on due date and authorize you to debit our account on the due date. Now, again, just to recapitulate, this happens in first week of June. And there is email correspondence which says that money will become now due on 19th November. So, though I have paid to the beneficiary, the applicant will be liable to pay this amount to Canara Bank on 19th November, and I in turn will get that money on 19th November. So this is the credit which is facility which is enjoyed by them. It has nothing to do with anything else about delivery of vessel. Therefore, this entire credit period argument I'll separately deal with. But the point is that they undertake on 3rd June that we will pay on the due date. Now, when you are issuing a letter on 3rd June saying that we will pay on the due date, would this pleading in paragraph number 11 not get completely, rather it gets established beyond all doubts that this is nothing else but a concocted averment in the case. It's a case which has been put up deliberately, suppressing a very vital document. In face of this document, the argument of suppression has been trivialized, that what benefit do we get, etc. No, if you want to actually explain your conduct with reference to this page 33 document, will this averment be an accurate reproduction of the facts? The answer to that is no.
if you read the two documents of 1st June together, it is very evident that you have cleared the documents and you have agreed to pay. Meaning thereby that you are mindful of the fact that the vessel has not arrived. You are mindful of the fact that notice of readiness is not, but I am giving clearance to the Canara Bank that please go ahead and pay. And therefore, you also mentioned that kindly inform the DBS Bank Singapore accordingly in the letter of 1st June. So, there is complete, in my respectful submission, there is absolute lack of coordination in the pleadings. You say that it is for a certain purpose that this letter is issued. When you read that letter, it doesn't really support the purpose for which you have allegedly issued the letter. And then you interpret the letter, ignoring another letter, clearly suppressing the other letter, and that other letter clearly goes on to demonstrate that your own reading and understanding is a convenient pleading. Therefore, my submission today is yes. So, because my submission to your honor today is that please consider this wise, that for the purpose of, we are here for the purpose of interim injunction. Prima facie case will have to be established. You are therefore pleading two things. One is you are pleading a case of fraud for the purpose of prima facie case, saying that there should not be payment by the Canara Bank to DBS Bank, and Canara Bank should not recover that money from me. That is the injunction which you want. Because the moment Canara Bank pays to us, they will adjust whatever monies they have against the amount which is outstanding. So this is the injunction that you want. So for the purpose of this, you are saying two things. First is, you are saying that this is a case of fraud. And second, they are saying is that the presentation of the letter of credit is not in accordance with the terms of the letter of credit. These are the two things which they have said. So answering the first case of fraud, in a minute. Yes. So as far as the first case of fraud is concerned, I would very respectfully request your honor to have a look at the entire plaint in detail, because I am not taking the trouble, but what has been argued by my learned friend doesn't get established. It is not, the foundation is not there in the plaint. That is what I would respectfully submit. That is number one. I would submit that yes, if the matter is seen in its totality, it is a clear case where they relied upon Capital Corp. They were aware about the problems with the vessel. They permitted payment to Capital Corp, bona fide believing that the vessel will eventually come. Capital Corp thereafter, for some reason, has not been able to deliver the vessel. Now today, therefore, the position is that they are not in the position to recover money from Capital Corp. So they will have to find a scapegoat. So they collude, the Canara Bank and the plaintiff, they collude with each other. Canara Bank conveniently does not answer the documents of 1st and 3rd June. They, in the plaint, say that there is negligence. Because I will once again re-emphasize that, your honor may, because when I say that this entire case which has been set up by my learned friend in his arguments, whether it gets support from the pleading, one line at page 27. However, defendant number 2 acted with gross negligence in issuing SWIFT message contained in the delivery report dated 3rd June 2021. Now, this 3rd June SWIFT message, when you say that Canara Bank acted with gross negligence, if you read it along with the previous pleadings, previous averments, you are trying to convey that I have not authorized Canara Bank to issue this SWIFT message permitting my client, DBS Bank, to pay the money to the beneficiary. That is what you are trying to convey. That is what you mean when you say that Canara Bank has acted with gross negligence. Now, if it is a case of gross negligence by Canara Bank, how is it that Canara Bank doesn't suffer? And in spite of the gross negligence by Canara Bank, as averred by the plaintiff in the plaint itself, I, as DBS Bank, will suffer this. If anybody should be out of pocket going by the plaintiff's own case, it is Canara Bank. Canara Bank is bound to pay to me. And therefore, because Canara Bank is acting in my respectful submission, it's very surprising, because in the banking world, this kind of stand by a bank is unacceptable. But Canara Bank obviously wants to somehow protect the plaintiff. Plaintiff comes with a case that, sir, look here, I've been duped. I have not received 26 crores. Fine. So if you do business with somebody without either you were aware about it or you are not vigilant enough. In either case, how is it that DBS Bank is supposed to suffer? Therefore, this entire argument of fraud, in my respectful submission, is a self-serving argument which has been conveniently set up, which does not get supported by the documents. And my respectful submission is that if one were to see prima facie whether there is actually a fraud or not, I would respectfully submit that this is not a case of fraud. Prima facie, at least it doesn't emerge from the pleadings which are available and the documents which are available that there is some fraud. And ultimately, it is a matter of trial. So today, to get an injunction on this specious plea of fraud without supporting or substantiating, in my respectful submission, this is not the stage at which Your Honor would say that yes, there is a fraud. Well, that is my first submission. Now, assuming for the sake of argument that there is a fraud, let's assume. The fraud is by whom? Fraud is by Capital Corp. Again, Your Honor, when Your Honor goes through the plaint thoroughly, Your Honor will find that all the allegations against the plaint about fraud are by Capital Corp. But the plaint, in my respectful submission, is in three parts. First of all, they talk about the agreement, they talk about the LC, the amendments, etc. Then they come to this paragraph 11, where they very conveniently deal with this 1st June document without referring to the other 1st June document, suppressing it clearly. And then they go on to say that vessel thereafter was not delivered. We kept on reminding this, that, etc. At some stage, we realized that this is all a case of fraud, that there is an indonation. Now, this is again will require a very detailed scrutiny. This averment of the plaintiff can't be taken as a gospel truth. But this stand of the stand of the plaintiff, they are playing the victim card. They are trying to invoke some sympathy in their favor by saying that, sir, we are innocent businessmen. We never realized this. We were not aware. No, it is impossible. And this again will require a trial. They will have to face the cross-examination by us on all this that you say. How is it that you are not aware? If a vessel of this nature, because these are all information available in public domain. If a vessel is attached lying somewhere under a court order, it is information available in public domain. So how is it that you are not aware about it? These are all questions which they'll have to answer. Today, very conveniently to say that, no, sir, we were not aware, this, that, etc. So because my submission is that fraud, first of all, is not getting established from the pleadings of the document. Secondly, there is no allegation of fraud against me. And what is important is, there is no allegation in the entire plaint that on 1st, 3rd, and 7th of June, so in the first week of June, when these documents were presented, I sent them to Canara Bank. Canara Bank gave a clearance, I paid. There was any allegation of fraud. There was any knowledge of fraud. And at least there is no averment to suggest that there was knowledge of fraud on my part. Because I'm saying this because the Supreme Court judgments which I have shown and which my learned friend Mr. Shah has shown, both talk about knowledge of fraud on part of the bank. So, what the law, as I understand, is that fraud, a matter between the two parties, is not relevant for the purpose of bank guarantee or letter of credit. It is the fraud which is underlying the bank guarantee. So we are concerned with the contract of bank guarantee or a letter of credit. So if there is any fraud concerning the bank guarantee or letter of credit, then yes. And third and most important is that the banks concerned should have knowledge of the fraud. So Canara Bank should have knowledge of the fraud when it is issuing or it is accepting the documents, issuing the SWIFT message on 3rd June, and that I should also have knowledge of that fraud. Only if that is shown would an injunction ever be issued. So this entire argument about fraud, because it may sound very appealing when it is presented so passionately that, sir, look here, I am a big victim, I am losing 26 crores, but it is every businessman loses money. So, Milos, if you are losing 26 crores, it is not my fault. It is nobody's fault. It is entirely your fault. Either you had knowledge, you relied upon somebody, or you are not vigilant. In either case, Milos, how is DBS Bank to be blamed for that? So, Milos, this much as this is what I have to say on this argument of fraud. I am also obliged to my learned friend, because the averments made in the plaint and what was argued by my learned friend is that we were blissfully unaware about everything. We blindly relied upon everybody. But then one fine day when we sat and we thought that why is the vessel not coming, we ordered an inquiry privately. And we came across all these documents and we realized that this vessel in fact is under an injunction or attachment. Now, because if you could undertake due diligence after 2.5 months of the transaction or after 3 months of the transaction, could you not have undertaken due diligence? And because on the face of it, it is unbelievable. It's on the face of it unbelievable. Because this plaintiff coming and saying that I had not undertaken any due diligence to find out what exactly is so because wrong with the vessel. So because these are all matters to be tried today for the purpose of injunction. All that has to be seen is whether I have acted bona fide in negotiating the letter of credit and whether I have acted in terms of the letter of credit. So because the second part of my learned friend's argument, because as far as fraud is concerned, this is what I have to say. I will again because now because the second limb of his argument is that let's forget fraud for the time being. Even the condition precedent of the letter of credit is not complied with. Now, this use of the word condition precedent. Now, what normally happens is that I, as a banker, who is either a nominated bank or a negotiating bank, when I receive the documents from the beneficiary, I will forward the documents to the issuing bank. And I will show from the UCP also that it is my obligation to forward it to the issuing bank. So there is no, it is sought to be projected that I could not have even forwarded the documents to Canara Bank. Absolutely fallacious argument with the greatest respect. If I receive as a banker a letter of credit with the documents, it is my obligation, I'll make it good with reference to UCP, it is my obligation to forward them to the issuing bank. For two reasons. Because in law, if a certain condition is attached for the purpose of payment, it is a condition for the benefit of the applicant, the issuer of the letter of credit, in the present case of plaintiff. And all conditions of a letter of credit can be waived. It is open for the issuing bank to obtain a confirmation from the issuer or the issuing bank itself to waive a certain requirement of a letter of credit. And therefore, the UCP, first of all, cast an obligation on me to collect, forward them to Canara Bank, and there is that entire article about waiver. Now, this argument about waiver has completely been, in my respectful submission, very casually brushed aside. So what waiver? This is a condition precedent. Because this is not unlike a statute where for assuming jurisdiction, you have to comply, there has to be a condition, the law provides for a condition precedent that if this fact exists, you will assume jurisdiction. But this is a banking transaction. It's a letter of credit. We are not talking about some quasi-judicial or judicial functioning where you talk about assumption of jurisdiction, non-satisfaction of condition precedent. So what actually has to be seen is that what are the terms of the letter of credit. Therefore, Your Honor may kindly have a look at the letter of credit in my compilation. I want to only show one thing, page 9. Page 9, field 40E. I have shown it to the Honor, but please note this now, because in context of what has been argued. 40E, applicable rules, UCP latest version. Your Honor has that, plus 40E at page 9. Now, this is the letter of credit. It is not in dispute that we are governed by UCP latest version. So the terms of the UCP, when we are talking about a non-compliant presentation, condition precedent, this, that, etc. Ultimately, what is to be seen is that in terms of the letter of credit, what are the requirements? What are the conditions? What are the documents required? What are the conditions for presentation? And for that purpose, the UCP is incorporated by reference into this. Therefore, for all purposes, the terms of the UCP get incorporated into the letter of credit. Now, Your Honor, may kindly see UCP. My friend, at Article 2, Article 2, my friend showed complying presentation. No, but we have a better copy. Better. Complying presentation means a presentation that is in accordance with the terms and conditions of the credit, the applicable provisions of these rules, and international standard banking practices. Three things. Terms and conditions of the credit. So when we talk about field 46B, 46(7)A, we are talking about terms and conditions of the credit. Therefore, letter of credit, terms and conditions. The applicable provisions of these rules and international standard banking practice. Three things are there. Now, Your Honor may see what are the terms and conditions. So, if we talk about the terms and conditions of the letter of credit, we have this amendments by which originally physical presence of the vessel was a condition, it was a requirement of required documents. So some document to show that the vessel has reached Alam. But these amendments will also have to be explained to them by them at a trial as to why did they agree. If they were so mindful of their rights and to ensure that we are not due, the amendments they could not, but that apart. So first requirement is, if we go by the original letter of credit, that there has to be physical presence of the vessel. That eventually got changed from physical presence of the vessel to notice of readiness. That again got changed from the required documents to the other requirements. We'd say, now in this context, Your Honor may kindly have a look at the language of that amendment, which is now being relied upon to contend that, please see page 16. Page 16. First of all, a tested telex or swift advice from the opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang, that the vessel is ready to be delivered physically to buyers. This was the first amendment. Now we are really concerned with the amendment by which there is a shift from field 46B that Your Honor will find at page 21. Now this is initiated by Capital Corp. Page 21. It says in additional condition 47A following to be added. Document to be presented after receipt of an authenticated SWIFT message as under. So document to be presented after receipt of an authenticated SWIFT message as under, a tested telex or SWIFT advice from the opening bank confirming that the buyers have received the notice of readiness from the seller or seller's agent at Alang, that the vessel is ready to be delivered physically to buyers. So this, according to them, is a requirement for the purpose of presentation. Let's go along. Let's assume for the sake of argument that their reading of this is right. So what happens? That the beneficiary of the letter of credit will come to me with a bunch of documents, which obviously does not contain this. It doesn't contain this. Now, do I at that stage itself stop the further process and return it to the beneficiary saying that no, this is non-compliant? My friend's extreme argument is that no, you just cannot forward it to Canara Bank. You ought to have been vigilant to find out whether the vessel is actually delivered, whether there is notice of readiness or not. So if this document is absent in the bunch of documents, I had to either ask for the document or I had to independently verify. So because my friend at the trial will have to show that there is some such practice. I will show from the UCP that this is not what is contemplated at all. So they are pitching their case as high as to say, to succeed in this matter, Your Honor will have to take a view that, and that is what the trial court, and that is where the apparent error and the perversity comes in. The trial court takes a view, my friend contends, trial court takes a view, and that is the view my friend wants Your Honor to take, that at this stage itself, when the beneficiary came to me with a set of documents, I should have told the beneficiary, I can't do anything about this. This particular document is missing. I am giving it back to you. Now, because I continued with the process, according to them, I am not entitled to the money. And this, according to them, is a condition precedent. With the greatest respect, because it's at the best a requirement of the letter of credit. It is at the best of requirement of letter of credit, matter of interpretation. This language is matter of interpretation. Document to be presented after receipt of an authenticated SWIFT message as under attested telex or SWIFT advice from the opening bank. Opening bank is Canara Bank. Confirming that the buyers have received the notice of readiness from the seller or seller's agent at along that the vessel is ready to be delivered physically to buyers. Now, please consider it from this point of view. That I am forwarding this to whom? I am forwarding this to the issuing bank, the opening bank. So the confirmation which is spoken of here is of that of the opening bank. So I am sending this bunch of documents to the opening bank, and the contention is that I could not have even done that. I should have stopped the entire process there and then, because it's unheard of. In the entire banking world, it is unheard of. This kind of contention, and this is the manner in which injunctions are to be applied for and to be granted with the greatest respect, as the Supreme Court rightly says, that it will ultimately, everybody will lose confidence, because you will find some or the other problem with the presentation. Trust me on this. Any beneficiary who is presenting, let's say 10 documents, 12 documents, there could be some or the other issue with the document. Therefore, the extreme argument of the plaintiff is that the person to whom the bank who is receiving the documents has to be so vigilant to scrutinize each and every document, and then to say that, sir, this document is not in accordance with the terms and conditions of the credit, etc. And therefore, I am not even going to forward it further. I am returning it. All business, all banking transactions will come to a grinding halt. That is not the pen that. Therefore, the UCP says, and therefore, very conveniently, those articles remain unanswered. UCP says that, please see, in this context, Article 7, which my learned friend relies upon. Issuing bank undertaking. So this is the undertaking of Canara Bank, issuing bank undertaking. Provided that the stipulated documents are presented to the nominated bank or the issuing bank, and that they constitute a complying presentation, the issuing bank must honor credit if the credit is available by side payment, etc. And then C, an issuing bank undertakes to reimburse a nominated bank that is honored or negotiating a complying presentation and forward the documents to the issuing bank. Reimbursement for the amount of a complying presentation under a credit available by acceptance or deferred payment is due to maturity, whether or not the nominating bank prepaid or purchased before maturity, and issuing bank's undertaking to reimburse a nominate is independent of the issuing bank's undertaking to the beneficiary. So because here we talk about the obligation of the issuing bank. Now, because issuing bank obviously will receive the documents only when a nominated bank or a negotiating bank will receive it from the beneficiary. So what is it that a negotiating bank is or a nominated bank is required to do? Because here in this case, sir, just I'm digressing, nominated bank and the negotiating bank are the same. If we look at the letter of credit, the nominated bank is DBS, and DBS also happens to be the negotiating bank. In a given case, the negotiating bank could be a different bank also, because the letter of credit is a negotiable document. So if a beneficiary holding a letter of credit goes to another bank, his own banker, and says that, sir, please negotiate this, that banker will simply receive the documents, put them in a cover, and send it to the issuing bank. That, sir, I have received those documents, tell me what I'm supposed to do. This is the banking practice, nothing beyond it. So because either the negotiating bank or a nominating bank is not expected to do what my learned friend expects them to do. Then please see Article 16. Now please see 15, because what is the complying presentation? Oh, before that 14. Article 14. A nominated bank acting on its nomination, a confirming bank, if any, and the issuing bank must examine a presentation to determine on the basis of documents alone whether or not the documents appear on their face to constitute a complying presentation. Now, this answers my learned friend's contention that I or the issuing bank is expected to undertake an inquiry to find out, and that is what the trial court also finds. This was a contention which appealed to the trial court, and the trial court finds that it is my obligation to find out independently whether the vessel is reached along or not, whether the notice of readiness is issued or not. Now, because if you go by the UCP, it very specifically says, and this is something I had emphasized earlier also, on the basis of documents alone. And this, if read with the earlier clause, which I have again emphasized in my argument, the bank, please see Article 5. Article 5. Banks deal with documents not with goods, services, or performance to which the documents may relate. So we only deal with documents. We just simply pass on the documents. So in this case, we passed it on to Canara Bank. Now, then what happens if in a given case? So that brings me to Article 16, 15, and then 16. When an issuing bank determines that a presentation is complying, it must honor. Issuing bank. When a confirming bank determines that a presentation is complying, it must honor or negotiate and forward the documents to the issuing bank. When the nominated bank determines that the presentation is complying and honors or negotiates, it must forward the documents to the confirming bank or issuing bank. So because if I am satisfied, I can straight away negotiate. But then I must forward the documents to the issuing bank. But in a given case where I don't straight away negotiate, then what is the procedure to be followed? It is in Article 16. Discrepant documents. So because I am given a choice. I am given a choice by Article 15 that I can straight away negotiate. If I find that the documents are compliant, then I will forward those documents to the issuing bank. But here, I act guardedly. So I go under Article 16 and I follow the procedure of Article 16. Discrepant documents, waiver and notice. Now, I was pausing here for a moment. Another argument which has come from the other side is that this is not a discrepancy. Sir, what is understood as a discrepancy is if a condition of a letter of credit, according to them, is breached, it's a discrepancy. If a document which is required to be supplied is not supplied, it's a discrepancy. So when UCP talks about discrepancy, it basically talks about a non-compliant presentation. When we are talking about discrepancy, so any non-compliant presentation synonymously is synonymous to a discrepant presentation or a discrepancy. Discrepant documents, waiver and notice. When a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank determines that a presentation does not comply, it may refuse to honor or negotiate. So option 1, refuse to honor or negotiate. Now this is sub-article B is very important. When an issuing bank determines that the presentation does not comply, it may, in its sole judgment, approach the applicant for a waiver of the discrepancies. Kindly note this. This does not, however, extend the period mentioned in sub-article 14B. I will read and explain it again. This basically applies to the issuing bank. Now, sir, if a document is discrepant, if a presentation is discrepant, at my end, if I notice that the presentation is discrepant, one option is under A, I will say, I will refuse to honor. But if I feel, and that is what as per the standard banking practice normally happens across all banks, I will immediately, even if I find that a presentation is discrepant, I will immediately send it to the issuing bank. And under B, an issuing bank can obtain a waiver from the issuer, the applicant. Therefore, let's read it again. When an issuing bank determines that a presentation does not comply, it may, in its sole judgment, approach the applicant for a waiver of the discrepancies. So here in this case, Hussein is part. And that is precisely what happened on 1st and 3rd June. When I forwarded the documents to Canara Bank approached, because it is not out of the blue that they've issued the communication of 1st June. My forwarding letter, Your Honor, if we go back to the documents, Your Honor will find at page 24. Sir, please note, this is, in my respectful submission, the most crucial document. It completely clinches the issue. We enclose documents relating to this drawing as required under the terms of the above documentary credit. Sir, it is not, I have done nothing. I have written this letter on 28th May. Please handle these documents in accordance with the instructions detailed below. We have enclosed the documents for your acceptance and payment at maturity. This I am writing to Canara Bank. Upon your acceptance, we will negotiate the presented documents under the DC. Advised due date and acceptance by authenticated SWIFT tested telex. We have endorsed the documents amount on the reverse of DC. So, and because at the bottom, this document is subject to the version of UCP for documentary creditors as mentioned in the credit. I'm also mentioning that I'm doing this under UCP. UCP would mean 16B. That I'm sending the document to you. Now you tell me whether you are accepting this or not. The Canara Bank could have told me that I'm not accepting. I would not have paid money. But Canara Bank tells me that I'm accepting. So we will go to that immediately. So in response to this, on 3rd June, sir, I am concerned with the communication between me and Canara Bank. So I have written to Canara Bank. Let us see what is Canara Bank's response, which Canara Bank so conveniently now wants to disown to help the plaintiff. At page 35. Sir, my letter very clearly says, advised due date and acceptance by authenticated SWIFT/tested telex. If Your Honor goes back to page 24, I have called for a response by SWIFT message tested telex. And this is that response by SWIFT at page 35. Narrative. Documents for US dollars so-and-so under LC reference have been accepted to be paid on 19/11/2021. We will remit the negotiated amount as per your instructions on due date. If the payment due date falls on a Saturday or a non-banking day in India, then the payment will be made on the following banking day. Please avoid duplication. Because this, nothing can be more clear than this, more categoric than this. And it gives me the date. Sir, I have asked for two things: advised due date and acceptance. So they advise the due date as 19/11/2021. Sir, how is this 19/11/2021 derived? they have worked out the 150 days from 22nd June. So 19/11/2021. So because what has happened? Why has this been taken as 150 days from 22nd June? That also I must explain. Because by this time, the letter of the MOA was amended and the date for cancellation, date of delivery has been extended to 22nd June. So from 22nd June, counting 150 days, they tell me that you will be paid. Now, my learned friend, Mr. Shukla, while arguing for the plaintiff, reads something into this communication which is not there. He says that, but Canara Bank possibly meant to convey that we will pay subject to delivery of vessel. Where is it? If this is the manner, and this is the manner in which this credits are to be denied to a negotiating bank, when the terms of this are as clear as they can be, what more is required for denying injunction, rejecting this application for injunction? We will remit the negotiated amount as per your instructions on due date, unconditional, unequivocal. Therefore, my submission is that when this communication is issued, now in this background, please come back to Article 16. Yes. Clause C says when a nominated bank acting on its nomination. So, sir, I have my letter of 20th May is in terms of 16B, where I ask for a due date and I ask for their confirmation. Then C, when a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank decides to refuse to honor or negotiate, it must give a single notice to that effect to the presenter, to the beneficiary. Then please see D. The notice required in subarticle 16C must be given by telecommunication or, if that is not possible, by other expeditious means no later than close to 5th banking day following the date of presentation. A nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank may, after providing notice under so-and-so, return the documents to the presenter at any time. So, because in a given situation where the issuing bank says that this is not acceptable to us, then this is the procedure to be followed. But if you see the next two articles, if an issuing bank or a confirming bank fails to act in accordance with the provisions of this article, it shall be precluded from claiming that the documents do not constitute a complying presentation. So, Milos, this entire argument that the presentation is not compliant, Milos, put it in whichever way, that condition precedent is not satisfied, it is discrepant, it is non-compliant. At the end of the day, the bottom line, your argument is that where is the notice of readiness? Where is the evidence to show that the vessel has reached India? Where is the material to show that Hussein Ispat is going to receive the vessel? If in absence of that, this negotiation could not have taken place at all. That, not with the greatest respect, is not the law at all. UCP, which are incorporated by reference into the letter of credit, very clearly says that if you do not raise the issue, then you will be precluded from claiming that the documents do not constitute a complying presentation. Now, this regulates the relationship between me and the issuing bank. Today, the matter is entirely between me and the issuing bank. I am calling upon the issuing bank. So, issuing bank tells the plaintiff that I am now under an obligation to pay. You do what you want to do. Go file a suit. I'll come and support you. So, the issuing, applicant files a suit, and conveniently, Canara Bank is sitting on the fence. Before the trial court, they openly supported the plaintiff, but here, when they realize that open support will be misconstrued, now they sit on the fence. They show the law to the honorable court that this is the law. So, and then G, when an issuing bank refuses to honor, or a confirming bank refuses to honor or negotiate, and has given notice to that effect in accordance with this article, it shall be entitled to claim a refund with interest of any reimbursement made. Again, we are not concerned. So we are basically concerned with F. We are concerned with B, we are concerned with F. Procedure of A, 16A, B and F has been followed by us, as is evident from two documents, 20th May, read with 3rd June. That in itself is good enough for me to get my money. Now, if the plaintiff has an issue with Canara Bank, as is mentioned in the plaint, if they feel that they have acted with gross negligence, then they can obtain an injunction against Canara Bank. But they are at the mercy of Canara Bank. They are enjoying facilities of Canara Bank. So now let's jointly look for a scapegoat. And that scapegoat is the BS Bank. This is what the matter has come to. Now let's dealing with their further submissions. My friend has very elaborately and painstakingly pointed out my conduct post termination. That September 2021. Thank you. With your honor's permission. So they talk about my conduct post presentation. Sir, my conduct post presentation is thoroughly irrelevant, to say the least. Now it is an argument which is available to them to basically create some prejudice. Let's see the manner in which they have acted. Now let's take it that what they are saying is right. I have answers to that. I'll give them a little later. But let's take it that yes, I did not inform them. But there are two arguments which have been made. One is that they were blissfully unaware about the fact that the issuing bank has issued the 3rd June communication permitting me to pay the beneficiary. That is one thing which they say. And they are not aware about the fact that I have actually paid. These are their two contentions. And they said that we become aware about it for the first time in October. Absolutely incorrect. Belied by the written statement of Canara Bank itself. Very clearly on oath, Canara Bank has declared, of course, the document, but they said that the SWIFT message of 3rd June was forwarded to Hussain Isfah. Now, because here, again, as I said, these are persons who are getting LCs issued on a regular basis. They know how LCs operate. So if they have received the 3rd June communication from Canara Bank, then they were obliged to react immediately. That, sir, how have you permitted this? On what basis? So again, if your honor sees page 552 of this compilation,
which page?
Paper book, please see page 547 first. This is the written statement of defendant number 2. I should please see the averments and see the manner in which very softly Canara Bank presents its case before your honor. Yes. Page 547, very first paragraph, that the present suit is a classic case of misrepresentation, falsehood, twisting of facts, manipulative tactics adopted by plaintiff, and the entire suit proceeds on erroneous depiction of facts, and the plaintiff seems to have deliberately resorted to malicious efforts to misguide this honorable court, and therefore I respectfully submit that this suit is not maintainable in law. Now, is this the tenor of the submission today before your honor? No. Well, they very softly tell your honor, sir, this is the law. If you tell me, I'll pay. Otherwise, I won't pay. But this kind of conduct is required to be deprecated. Now, please see page 552. Somewhere in the middle, added it, 6th line of para C. It is transpired that ship is about to arrive on 15/6/2021. Accordingly, the defendant number 2 informed the defendant number 3 with a SWIFT message dated 3rd June 2021 that the documents have been accepted and the amount of letter of credit will be paid on 19/11/2021, assuming that the delivery of the vessel and notice of readiness, etc., will be provided on or before 22nd June 2021 as per the terms and conditions of the letter of credit. Now, please note this words, and the copy of the said SWIFT message was also forwarded to the plaintiff as per procedure and not disputed by the plaintiff. The copy of the aforesaid documents are attached with separate list. And it is this Canara Bank which, along with the separate list at page number 559, Please see what documents they have produced. Page 560 is the letter of credit. The copy available with them is produced. Then please see at page 565. The letter written by Canara Bank, DBS to Canara Bank, which I have read to your honor in compliance with 16B, is also produced by them, coming out of their records. So they have received this letter is getting established. Then with the letter, the documents, whatever I had forwarded, page 566 onwards, are the documents which I had forwarded. Then your honor will find. Yes, whereas somewhere in between at page 567, the form of acceptance, the document which I say is suppressed, it comes from the custody of Canara Bank. So because this kind of collusion, the plaintiff withholds, but Canara Bank produces. And fortunately for us, Canara Bank produces. Because when they prepared the return statement, they were in a different frame of mind. And because I'll tell you, honor, what happens, sir. In the banking world, there is a practice. Now, if they today, in face of their swift message of 3rd June 2021, on the record, take a stand against the plaintiff, there would be consequences. There are international courts where these disputes would be tried. So, for the record, they are taking a stand that this is frivolous, vexatious, this, that, etc. They produce all the documents. When it comes to arguing the matter before the honorable court, they take a very soft stand towards the plaintiff. In fact, Canara Bank should be vehemently contending before your honor that, sir, nothing doing, I am obliged to pay to DBS Bank, permit me to pay. But that doesn't happen. So, because these are the documents which Canara Bank has produced. And then at page 570, it is a swift message of 3rd June. Which they say in paragraph 16 has been forwarded to the plaintiff. So this completes the entire chain. I write to them on 28th June. They obtain confirmation on 1st June from Hussein Ispat. Then they issue a telex to me on 3rd June. And that telex is sent to Hussein Ispat on 3rd June. Now, in face of these documents, it is today being contended before your honor to create some prejudice against me. That please see the manner in which I have conducted myself. Sir, I have not, as a banker, I have simply followed the procedures. So it is not as if I was, and it can't be anybody's case and it is nobody's case. That for this amount, a bank of my size and my reputation would collude with, is it anybody's case that I have colluded with Capital Corp to facilitate them to receive money from me? That is nobody's case. So because why my bona fides are not under doubt. All that they are saying is that you should have been more vigilant. The law doesn't require that. The matter should end there. Moment I obtain, and sir, let apart, take a scenario that I missed it. I genuinely missed it. I missed the fact that the notice of readiness is not there. It can happen. We are also prone to errors. So I commit that error. But that error could have been corrected by Canara Bank. They could have said that, sir, where is the notice of readiness? They could have corrected that error. They could have told Canara Bank that, what are you talking? Nothing doing. There is no notice of readiness. The vessel is nowhere in sight. It is not in Indian waters. What are you talking? I am not going to issue any such communication. Because all this is now being conveniently argued before you, with the greatest respect. So because my conduct post termination, as I said, is irrelevant. But nonetheless, let me just show pages. Email chain, page 233. Sir, my friend has today showed one document, which is part of a chain of emails, which start from page 233 of this compilation. Sir, at the bottom of page 233, page 233 bottom, there is an email. Greetings from Canara Bank. Hope you all are staying well and safe. I am writing to have your kind assistance on the following matter. We refer to following swift messages. The above cited LC was opened by our branch on behalf of applicant Messrs. Hussain Ispat, advised through so and so. Further, as per mutual agreement between applicant and beneficiary, has informed we did their request letters attached to cancel the said LC. Consequently, we have sent requesting your good bank to consider the request of parties and treat the above so and so null and void, and also request and to confirm the same through authenticated SWIFT message. Unfortunately, till date, we have not received a response from your good bank. So this is being forwarded from Canara Bank to DBS Bank. So your honor may mark 1 against that. This is the first letter, email in the chain of letters. Then just above that is the answer. So it's going backwards. So your honor, at page 233 against the email which I just read, note number 1, that is the first email. Then above 1, 2, just above 1, there is an email which says, "Hi Vishwa, kindly write to Santosh what the same." Now Santosh is a local person in India. So this is inter DBS. We forward it. Then please see the previous page, 232 at the bottom of the page. So Vishwa forwards it to Santosh. Can you please please check our trailing mail. That is number 3. Then above that, Vishwa again writes to Santosh. "Hi Santosh, tried reaching you over phone, no luck. Please let us know update on subject matter." So now Vishwa is writing to Santosh, page 232. Now I'm reading the middle, which is the 4th email. Then top of the page is the 5th email. As discussed, so Santosh is now responding. As discussed, we are taking Benny, therefore beneficiary, who is Capital Corp, consent for the cancellation, will respond accordingly. So, because lot has been said about what were you doing all this time. So I had indicated in my opening arguments that an LC cannot be cancelled. It is already honored. Payment is already made. So if the payment has to be routed back to Hussain Ispat, then the beneficiary will have to cancel. So we said, as discussed, we are taking beneficiary consent. Benny means beneficiary consent for cancellation and will respond accordingly. That takes me to the previous page, 231, bottom. Now, this is what is being harped upon. "Hi Vishwa." Santosh is writing to Vishwa. "Hi Vishwa, cancellation took place yesterday. You will receive SWIFT soon." So this is the message on the basis of which they are saying that the cancellation has taken place. But this was an error which comes later. So Santosh writes to Vishwa saying that cancellation has taken place. Then see the previous above, page 231, which is the 7th email. Santosh is receiving from, again, an internal email. This is in reference to our call earlier. "I have attached here the letter supposedly given by beneficiary to the LC to DBS for cancellation of LC. This letter is dated 27/9/21. Since credit lines of our client are blocked because of this LC not being cancelled, there is intense pressure on our side for cancellation of this LC. Please help us." So this is coming from the Canara Bank to us again. So this is the 7th email. Now please see the previous page. At the bottom, this is again from them. They are saying, "We are yet to receive any update from your end. The matter has been pending for long now. We understand the beneficiary has given consent with their letter, which I already shared with you. I suppose this was what DBS was waiting for, in which case we should be receiving the cancellation confirmation immediately." Now, the top of the page. Page 230. "Hi, so-and-so. Received following reply from SG." Now, Santosh is the person who had written at page 231 the email which said cancellation took place. So now this is an email which quotes the message from Santosh. It says, "Received following reply SG Santosh, SG Singapore. Please ask your applicant to speak to beneficiary on this issue." And then it says, quote, "Dear Santosh and Cheryl, I have spoken with the client and he confirmed that he is cancelling another LC and not this particular one that was issued since April 2021. So we are constantly in touch with the beneficiary. We are telling him that why don't. So initially he says that I'm cancelling. On the basis of that, Santosh says it is cancelled. Then the beneficiary, that is Capital Corp, says that it is the other LC which I was talking about, not this one. So accordingly, we write to them saying that this is not happening. And then and the underlined line, this LC reference shall continue and is not agreeable to the cancellation. So beneficiary finally tells us and we communicate to them. So this entire argument about, please see how they have conducted, both arguments. First of all, they said that we are completely ignorant about the fact that on 3rd June, they permitted me to pay, and on 6th June, I have paid. I am unaware about it. Seriously doubtful. Belied by the written statement of the Canara Bank. They have no reason not to say anything untrue. They very clearly said that we had informed and that we are not aware about anything else. If my respectful submission is something which on the face of it is unbelievable, and at this prima facie stage, no, and let us assuming they are right, if they continue, they establish at a trial that they had no knowledge, or that for a month and a half, for 35 days, I was not responding properly. And I eventually told them only in October that this money has been paid. What turns on it? If I have followed the procedure, and therefore I am saying that it is a matter between me and Canara Bank, I need to show to your honor's satisfaction that in terms of the letter of credit and the UCP, I have called upon Canara Bank. Canara Bank has confirmed, and I have paid. The money should come to me. If it is there, if they have a grievance against Canara Bank, please take it up independently. But I can't be denied this payment. Therefore, Milos, as far as this argument, as I said, it is an argument to create invoke some sympathy, but it is not an argument which can be accepted in law. No, one argument which has repeatedly been advanced is that when the vessel was to be delivered on 15th June, their main argument, and with the trial court also accepts, that the vessel was to be delivered on 15th June. There is an amendment. You are aware about it. Where is the question of making payment on 3rd June? Answer to that is very simple. That if the vessel is not delivered or was to be delivered on 15th June, it was either for the Canara Bank or for you to say that, sir, vessel is not yet delivered, no question of payment. I would have stayed my hands, I would have stopped. It is not that I have gone out of my way. Sir, this entire argument would hold good if I had not written to Canara Bank on 20th June. Under the UCP, 20th May, had I not written to Canara Bank on 20th May, because all these arguments do not hold good at all. When I have written to Canara Bank, as I have pointed out from the UCP, I have an option to negotiate if I am satisfied with the documents, or I have an option to forward them to, but to be on the safer side, I will never negotiate. I will always take confirmation. I will never venture to negotiate of my own, even though I have the right to do so, if I am satisfied with the documents. So I exercise the other option of asking Canara Bank. Now, once Canara Bank confirms, I am not concerned whether the vessel was to come on 15 June or on any other date. I am not concerned with your problems with the seller. How am I concerned with all this at all? Therefore, this argument is again an argument which may find with the trial court at least finds very attractive, and the trial court judgment entirely proceeds on the basis, but sir, where is the vessel? These people have been duped, but it is your own doing. That is my respectful submission. Then the other aspect of the same argument, again repeated many times, is that very interestingly, because this is a spin which the plaintiff gives, that Canara Bank has not agreed to pay irrespective of delivery. This is the words in which this argument was advanced by the plaintiff. 3rd June is capable of any other construction, and it is not Canara Bank's case. Canara Bank has not said or not contended before your honor even today that
Canara Bank has said their October letters. Forget.
But that is something I am talking about 3rd June.
No, but my friend is arguing that Canara Bank has not said this. But kindly read those October emails of Canara Bank.
Canara Bank.
They themselves said that it was a tentative maturity date dependent on the physical delivery of the
So,
vessel.
what your honor needs to consider is this, that very conveniently, let's take it, that today, was it Canara Bank stand on 3rd June? That is relevant. I have acted to my prejudice on the basis of 3rd June. Now, 3rd June, sir, this is all conveniently happening. They don't want, they are clearly duped by Capital Corp, and they are looking for a scapegoat. So, October onwards, Canara Bank starts singing a different song altogether. On 3rd June, having said, so what falls for your honor's consideration is this argument available in face of 3rd June? Now that they are looking for a scapegoat, they are in tune. But can this be countenanced? Because 20th October, now whatever they say is irrelevant. 28th, 29th, 30th, whatever, November, December, whatever be your communication. The point of the matter is that what did you tell me on 3rd June? That is important. So, because all this, with the greatest respect, now, because repeatedly it was told to your honor that, sir, look here, our plight. We have lost 26 crores. If we are made to pay without the vessel, we are fine. So, am I supposed to bear that burden? And for what reason? Having acted to my prejudice based on your communications, which you now want to conveniently interpret and misread and misconstrue with the aid of the bank, am I to lose the money? Therefore, because this argument that we have lost 26 crores is thoroughly irrelevant, absolutely irrelevant. Because it doesn't. I mean, my friend also said. Friend also said that look here, the trial court has said 3 months the trial can be completed. Now, today I am told that there is a substantive application for amendment, which your honor will find in the record. And if the amendment which is sought is seen, which is so far not granted, so we are still at the stage of amendment of the plaint. Nonetheless, any litigant who is sitting with an injunction is bound to very conveniently tell your honor, sir, look here, what is the big deal? This matter can be finished in 15 days, 20 days, appoint a court commissioner, evidence to be recorded, this, that, etc. The fact of the matter is that the matter has not moved an inch after the injunction. On the contrary, you filed a.
Sir, they look good amendment.
This is not fair. Mr. I did not utter a word when you were arguing. I was tempted to get up at least on 15 occasions when you were arguing. So please now wait for your turn. No, this is my argument. So, this is something which is being very across the bar being stated without reference to the record. The fact of the matter, I am trying to make out a different point, that you are sitting with an injunction. Therefore, it's again a convenient argument that, sir, don't disturb the injunction. What is the big deal? Ultimately, only 3 months, this, that, etc. A trial of this nature will never conclude in 3 months. We have an application for amendment which is still pending. If granted, the matter will go further. If not granted, it will go further. So, because this is not a matter which can come to an end, and that apart. So, point is that has the injunction been validly granted? Can today, if I'm right in my submission, can I be denied relief only on the ground that the trial can be concluded in 2 or 3 months? If the injunction is wrongly granted, it must be vacated, irrespective of the stage of the trial. It invariably happens. The matters proceed further, the higher courts reverse the injunction. So, that is of no consequence. Nonetheless, federal bank judgment was sought to be distinguished on the ground that it is on different facts. And my learned friend said that by referring to the facts of federal bank, that look here, the distinguishing fact is that the receipt of the goods is acknowledged. So federal bank was the case where your honor would recollect, the goods are received, whereafter a dispute is raised, etc., etc. And eventually the court finds that there is acceptance of the goods. So if there is acceptance of the goods, then the LC has to be honored. That is what the federal bank says. Now, my friend is trying to distinguish by saying that there is no such acceptance here. And then he cites the other Supreme Court judgment that a judgment cannot be read as a statement, etc. Very settled principles. But how do you answer 1st June and 3rd June? When on 1st June you have issued a letter, on 1st June you have given in a printed format. On 3rd June, if the bank has given me a clearance, then would Federal Bank not apply? How are the facts different? Here also in this case, I'm relying on Federal Bank because I find in my facts identical facts, 1st June and 3rd June. So in face of 1st June and 3rd June, so the Federal Bank was sought to be distinguished without reference to the 1st June cyclostyle, the format letter, as they call it. Merely relying upon the 1st June, taking advantage of the language issues in the 1st June communication. But these are all matters to be tried. Today, on the face of it, Federal Bank applies. It applies. Yes. Now, my friend lastly argued. With reference to that 1st June format letter. First of all, he says that it is not a case of suppression. It doesn't say that, it says that it is not a case of suppression. I mean, that's when today there is a clear written statement filed by Canara Bank with which this document is produced. The plaintiff has not filed any further pleading saying that I was unaware about this document. Now, my point before your honor is that would a lot not turn on that format letter of 1st June, which clearly shows that Canara Bank, before issuing 3rd June communication, had approached them. Then it is a matter of explanation and interpretation. But could you have withheld that document? So the fact that they have issued 3rd June, 1st June, two 1st June letters is not in dispute. But they say that what suppression? There is no suppression here. And then they go on to say that, sir, these are ultimately format letters. There are blanks. So what? Before the trial court, they even contended and trial court records that it is filled in by the bank. The trial court records the finding. And therefore, when I read the trial court judgment, because I commented that without a pleading being there, the trial court goes on to record that this is something which is filled in by the bank. What is the basis? So when I come with deal with the judgments which are cited by learned friend about why an appellate court should not, but this is the kind of perverse, with the greatest respect. If the trial court, for the purpose of not rather giving any weightage to a document, says that I will not consider this document because I come to a conclusion that without there being any pleading, what greater perversity than this in the order? So all these arguments about this 2nd June, 1st June are not supported by pleadings at all. Not a single pleading today on record from the plaintiff. My friend also says that this acceptance does not carry the matter further. I would very respectfully submit that this acceptance is a clear acceptance of your obligation to pay. You are undertaking. The language used in this is undertaking. It's a format letter. In fact, the circular, the format has on the as a title, there is a reference to a HO circular, head office circular number so and so. So it's a prescribed format under an HO circular, which they are bound to obtain before. If we see the circular, your honor will find that this is the format in which they have to obtain an acceptance from the client before giving a confirmation to the nominated bank. So it is in that format Canara Bank has obtained, and this format letter, in my respectful submission, in this entire compilation of documents, that is the single most crucial document, along with 3rd June. And they say that no suppression, there is no suppression. So this is the background in which we very humbly pray that the trial court order needs to be set aside. Now, I had in my opening submissions, this is my prima facie case. Now, when I said that I am a bank and ultimately I am good for my money, I was saying in context of irretrievable injury. I was not trying to say that because I am a bank, don't grant injunctions. I am on balance of convenience, irreparable injury, as the Supreme Court says, if at the end of the trial, if there is an apprehension that this money, if it goes, will not come back, then it can be a ground for granting an injunction in rarest of rare cases. So we have the famous case of that Iran bank guarantee, where the Supreme Court says that if the money goes to that country, how will we ever get it back? So this is the kind of injury. In that context, I was saying that, sir, I am good for my money. Therefore, today it is nobody's case before your honor that if Canara Bank remits the money, as I am seeking before your honor, this money will not come back. I am good for my money. And therefore, the balance of convenience is also in favor of my clients. And sir, I will end my submissions by referring to 2 or 3 passages from the judgment cited by my learned friend. I'll deal with the authorities of Mr. Shukla and then I will come to that. Now, as far as the judgment cited by my learned friend, kindly take up Wander versus Entox. Paragraph 14. Paragraph 14. The appeals before the division bench were against the exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of the discretion of the court of first instance and substitutes its own discretion, except where the discretion has been shown to have been exercised arbitrarily, capriciously, or perversely, or where the court has ignored the settled principles of law regulating grant or refusal of interlocutory injunction. My submission precisely is this, that the case law, Federal Bank has been distinguished, applicable rules of law, the documents have been discarded. For example, I've already commented. So, this is the manner in which the trial court. Now, if this does not fall within the 4 corners of arbitrarily, capriciously, perversely, or has ignored the settled principles of law, which matter will fall under? Therefore, in virtually, you're saying that appellate jurisdiction can't be exercised. An appeal against exercise of discretion is said to be an appeal in principle. Appellate court will not reassess the material and seek to reach a conclusion different from one reached by the court below, if the one reached by the court below was reasonably possible on the material. My submission very clearly is that the view taken by the trial court is not a possible view of the matter at all. The appellate court would normally not be justified in interfering the exercise of discretion under appeal solely on the ground that if it had considered the matter at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably in a judicial matter, the fact that the appellate court would have taken a different view may not justify. Sir, I am saying that please apply para 14 and please see my grounds of challenge. Please see my arguments. I am very clearly contending that this exercise of discretion is unreasonable, it is unfair, it is perverse, it is against the settled principles of law, it has been arbitrarily granted. And I have read the findings, each one very elaborately, and I have offered my comments on that. So, Wander versus Entox will not come in the way if your honor is convinced about my arguments. The other 3 judgments reiterate the principle of Wander versus Entox, so I am not taking your honor to that. Now, that brings me to Hindustan Construction. Hindustan Construction was a case where the bank guarantee provided the manner in which the bank guarantee is to be real. I assume and apply this principle as far as the facts of our. I am not saying before your honor that irrespective of what I have done, no injunction can be granted. I am saying that I have acted in terms of UCP, I have acted in terms of the letter of credit, I have relied upon their confirmation, give me the money. That is all that I am saying. Now, how is the invocation, the presentation? Because they will have to show that the present, when we talk about invocation not being in conformity with the letter of credit, obviously they are saying only one thing, that because there was no notice of readiness, you could not have sent the documents to Canara Bank. This is the kind of argument which they are raising in their. This is a well settled principle, that invocation has to be in accordance, but on facts, Your Honor will have to see whether it is in conformity with it. So I am saying that whatever I have done, it's completely and precisely in conformity with the letter of credit read with the UC. Now, the judgment cited by my learned friend Mr. Shah for the bank. Sir, I will emphasize only one line in those judgments where the Supreme Court says fraud to the knowledge, para 34. Now, I'm very heavily relying upon, and I'm obliged to which judgment? The first judgment in the compilation, running page 7. Running page 7 of Mr. Shah's compilation. Yes. Sir, para 34 has been read. I am not reading it again. I am emphasizing on the last 4 lines of the paragraph. On scrutiny, the confirming bank would ask for advice of the issuing bank to confirm whether the documents produced by the beneficiary is compliant to the terms and conditions of the letter of credit. So when I write on 20th May, this is what I do. Once the issuing bank confirms the document, the confirming bank is obligated to pay to the beneficiary on demand the credit amount and in turn recover the same from the issuing bank. This is what the Supreme Court says. So because once I have written on 20th May, I called upon the issuing bank. Because therefore, this judgment in my respectful submission squarely supports what I'm contending before Your Honor. Then, sir, para 15 and 16, running page para 15 and 16 of this compilation. Where, sir, in para 11.28, page 16. Yes. Again, I'm not reading because Your Honor has seen. There are 2 exceptions to the above rule. The first is that it must be clearly shown that a fraud of a grievous nature has been committed and to the notice of the bank. So, sir, what has to be shown is, because their own case in the plaintiff that we subsequently detected the fraud. Not on 3rd June, not on 1st June, not on 7th June. They subsequently detected the fraud. Now, if that is their case, where is the question of imputing knowledge of that fraud to me? They themselves say that we detected the fraud. So then they can say that, yes, but you are the perpetrator of the fraud along with Capital Corp. They can still say that. But that is not what they have said. It is nobody's case that my bank along with Capital Corp perpetrated that fraud. They are very clearly saying that I have not paid in terms of the UCP or the letter of credit. So there is no question of there being any fraud to my knowledge. That is what I want to show. Then page 24, para 14. Now, this Himadri Chemicals I have read, because when I read that GMB judgment of Supreme Court, Himadri Chemicals has been reiterated. Your Honor may kindly just bear in mind that these are the principles. And because very clearly the Supreme Court says on the next page, the court should be slow in granting an order of injunction to restrain the realization of a bank guarantee or a letter of credit. Since the bank guarantee or a letter of credit is an independent and separate contract and is absolute in nature, the existence of any dispute between the parties to the contract is not a ground for issuing an order of injunction or restraint enforcement of bank guarantees or letter of credit. So because their dispute is becoming irrelevant, that we have not received vessel, etc. Fraud of an egregious nature, which would vitiate the very foundation of such a bank guarantee or letter of credit, and the beneficiary seeks to take advantage of the situation. Allowing encashment of an unconditional bank guarantee or a letter of credit would result in irreparable harm or injustice to one of the parties concerned. So that is also not even pleaded. So because irretrievable harm is also not pleaded. So because here is a case where the only submission which is coming before your honor is that we have been duped by Capital Corp and I have not complied with the terms of the letter of credit. These are the only two arguments which are coming before your honor, which I have adequately answered. Now, because there is a reference made to a Madras High Court judgment. Well, this very interestingly comes from my learned friend appearing for the bank, where an injunction has been granted. But this is what I mean when I say that this is how the bank is supporting. You know that running page 65. Yes. Now, this was a case where, if your honor sees the facts, and I'll take your honor to the facts. But the distinguishing factor here is that the day on which I approached Canara Bank and Canara Bank confirmed the vessel had not reached was a fact not to the knowledge of the plaintiff, to the knowledge of Canara. In spite of that, a confirmation has been given. So, Milos, this argument is that on that day, yes, the vessel has not reached. So, what is alleged against me is only a technical breach. That how did you encash or how did you pay under the letter of credit in absence of this? Whereas here was a case where the date on which the LC was sought to be invoked, there was a dispute regarding receipt of the goods, there was a dispute regarding quality of the goods. So in that context, the Madras High Court has given an injunction. Now, though our facts, in my respectful submission, in our facts, this judgment will not apply. Kindly have a look at the 5 lines above paragraph. Or can I read from paragraph 15 at page 65? A perusal of the above decision would make it abundantly clear that when an unconditional letter of credit was given, the beneficiary was entitled to realize in terms thereof, irrespective of any pending dispute relating to the terms of the contract. The bank which gives such guarantee was bound to honor as per its terms, irrespective of any dispute raised by its customers. The court should not grant an order of injunction to restrain the realization of letter of credit as a matter of course, but should be slow. Since the letter of credit is an independent and a separate contract, and it is also an absolute nature, the existence of any dispute between the parties to the contract cannot be a ground for issuing an order of injunction to restrain enforcement of a bank guarantee or a letter of credit. To the above, the apex court has given 2 exceptions: fraud of an egregious nature, which would vitiate the very foundation of such a letter of credit, and the beneficiaries attempted to take advantage of the situation. And 2, if the encashment of an unconditional letter of credit is allowed, it would result in irreparable harm or injustice to one of the parties. If these principles of law settled by the apex court in the above cited decision are applied, this court is of the considered opinion that it is a fit case where the court has to grant injunction for the following reasons. Then, sir, the right-hand side, page 523 on right-hand side, the facts are discussed, bottom of that left-hand side paragraph. Hence, before the letter of credit in question was to be negotiated by the appellant, one amongst the conditions imposed was delivery of the material at so-and-so port. Now, here also, delivery of the vessel was a condition which was subsequently changed. In the instance case, admittedly, it was not done. So, in our facts, there was no scope for delivery because it has been changed to notice of readiness. It could be seen that for the negotiation of the letter of credit, though irrevocable, the delivery of the material is shown as condition precedent, and without satisfying the condition, the appellant is not entitled to negotiate or encash the letter of credit in question. As per above settled principles of law by the apex court, a beneficiary is entitled to realize the letter of credit in terms thereof, but not otherwise. In the case on hand, the appellate beneficiary is not entitled to realize the letter of credit since he has not acted in terms thereof by performing the condition as found in the letter of credit itself, namely clause 7.2. So this was the case where a beneficiary of the letter of credit came forward and said that, sir, the letter of credit is unconditional, it must be paid to me. And the contention which came was that where have you delivered? You have not delivered. And therefore, you can't be paid in terms of the letter of credit. Whereas in our facts, the delivery was not even required. What was, if at all required, was a notice of readiness. A condition which could have been waived. A condition which has been waived. Therefore, this is not a case where the principle of waiver under Article 16 was even considered or discussed. Whereas my entire case, relying upon federal bank judgment, is of waiver. So because there is a complete difference as far as this matter. So this judgment coming from the other side is, and then this article which has been produced, I would say that when we are covered by a judgment of the Honorable Supreme Court in Federal Bank, there is no need to refer to an article which does not even deal with the Indian law. We are concerned with Indian law as it applies to us. Therefore, my respectful submission is that please allow the appeal. Obliged.
Since my friend argued the appeal in the rejoinder, I just want 5.
No, I'm objecting to this.
Five-
I have answered his contention.
5. No,
But this goes on,
it won't go on.
This goes on. Then I'll obviously answer to whatever he has to.
You will not be able
But this
to
can't
answer.
be permitted.
You will not. No, I'm not touching on the facts. This amendment application we moved. Kindly look at the dates. Because the doubt is cast on my bona fides. Amendment is moved on 26th of July 2022. We are today in February 2023. In between 29th August, 21st September, 17th November, 23rd December, 3rd February. These are the dates which have gone. Today is, of course, these are the dates which have gone. They have applied for time to file the application. Reply. I don't want to file an affidavit. You refer to my amendment. You withdraw.
Statement of fact that an amendment.
You make a statement of fact without affidavit.
I am trying to say that such suits.
You can't.
The casual manner in which you said it can be completed in 3 months. I am controverting.
But sir,
That is the limited purpose. for which
reply
I am
આપ્યો હોય તો બતાડી દે મને. જે મને નકલ ના આપ્યો હોય પણ કોર્ટમાં ફાઇલ કરી દીધો હોય તો બતાડે.
Anyway, I think we have taken enough time of the honorable court.
So the point is that it is wrong to say that plaintiff wants to take the advantage of the delay. We will comply with the directions and we will certainly complete the suit. Although the trial court says that plaintiff must complete evidence within 3 months, we will say all parties must be directed to complete the evidence within 3 months, 4 months, whatever. But since November of 21, the injunction is in force and the trial must be allowed to continue with injunction. Obliged, sir.
Obliged to your honor, sir, for the patient.
You really want to complete today? Because sufficient time.
Saab, hame
Appeal, sir.
written submission.
Jarur nathi, sir.
Sorry, I'm just thanking all of you that you have completed your arguments.
Great,
Sir, in fact, we are obliged, your honor.
Reasonable time to read the matter and the dictate and the pronounce it because
No,
the
we must apologize for all the repetition. I am
last
quite.
17th of March, before 17th of March, I have to pronounce.
No, for any reason, if there is, your honor can
I'm
indicate.
indicate on tentatively on 10th, but before 17 I will.
Sir,
Sir,
Right?
obliged,
If it
obliged.
will matter on 10th. So the time will be expired on 17th of March.
On 10th, your honor can indicate, because if there is any problem, we can even seek extension. That should not be a problem at all.
10th.
Sir, Mr. Pandya on our behalf will receive the order. Our presence may be excused.
It was a pleasure appearing before.
Obliged, sir. Very grateful.
એક સાહેબ બેલ એક્વિટલ બોન્ડ
આપવાના છે.
સેશન્સ 20/20.
આજે આપીએ જજમેન્ટ.
હાજી આરોપી ને ના જામીન આર્ગ્યુમેન્ટ ચાલુ હતી એટલે
સાઈન વન બોલાય ને.
જામીન દાખલ કરાવો તમારો નામ બોલો.